Now, we talked about there being a lot of changes here in 2022 on Court TV. One of the changes is that plea day has been added to the afternoon of these miscellaneous dates. Now, plea day, as we call it, some people call it arraignment if you're in a different part of the country, some people call it arraignment here. That's really the first time someone is in court. Now, on plea day, you're going to see it's going to go very fast. The plea day part will go very fast. You're going to have people who haven't hired a private lawyer or are assigned to the public defender. If someone has hired a private lawyer by that point, that lawyer is going to file a waiver, what we call a waiver of arraignment, and a not guilty plea. So, for instance, that's what I do for my clients. My clients aren't going to go to plea day. But when I was a public defender, all of those clients go to plea day. It's a lot of times it's the first time a public defender is going to see that client. They're going to give them a card, they're going to set them an appointment, and they're going to get ready for that next court date, which is pretrial conference that we talked about in another video. This is a change because plea day last year was on a different day. It wasn't intertwined with this. This has actually streamlined it, put it all in one day. It does seem like it's a lot easier to take care of. After the plea day part goes, and that part goes rather quickly, then starts the afternoon of the miscellaneous VOP court date. The afternoon is reserved for larger hearings or contested VOP hearings, and I know we talked about those earlier. There's not a lot of those, but they do happen. But those other larger hearings, things like sentencings, when someone has entered a plea to a case, and they're going to come back and get sentenced by the judge, and they're going to bring in, people to testify. They're going to bring in their friends or family to speak on their behalf and bring in letters, and we're going to hear that compelling testimony about maybe why they should get less than what the state's offered or why they should get this or that. And those are always very, very entertaining, very riveting to watch. I know even here at the office, we stay glued to Crestview Community TV on these afternoons.
Jose Manzano Diaz. Diaz. Hello, Mr. Diaz. Yes, ma'am.
I'm the interpreter.
Yes, ma'am. Thank you. You'll swear in the interpreter?
Can you raise your right hand for me? Do you swear or affirm that you will make an accurate, complete, and impartial interpretation from the Spanish language into the English language and vice versa relative to the cause now under consideration before the court? I do.
Thank you, ma'am. What's your name?
Miss Villarreal.
Thank you. Nice meeting you.
You too.
Thank you, ma'am. Mr. Diaz, you're here because you're charged with DUI or alcohol. I'm sorry. Yes, DUI, alcohol, or drugs, fourth or subsequent offense. And also for driving while license suspended with a prior conviction. Does the state have an offer for Mr. Diaz?
Yes, Your Honor. At this time, it's adjudication of guilt at 12.1 months in the Department of Corrections.
Mr. Diaz, the reason why I ask what the state's offer is if they were offering you something that was probation or something that you may want to accept without an attorney, I wanted you and me to hear what that offer was. But since the state's offer to you is prison, do you wish for me to appoint the public defender to represent you if you qualify financially? Do you want an attorney?
Yes, the public defender.
Okay. How much money do you average making per month?
¿Cuánto dinero hace normalmente por mes?
Como $800,000.
About 800 or 1,000 a month.
Okay. I do appoint the public defender to represent you.
Entonces le voy a asignar el defensor público.
Mr. Kleins is approaching on your right.
Ahora,
I'm going to be your attorney.
yo voy a ser su abogado.
Okay. My name is Scott Kleins. Okay.
Señor Kleins.
I'm going to enter a not guilty plea for you. Your Honor, this is Scott Kleins on behalf of Mr. Manzano Diaz. We will acknowledge receipt of a two-count information, waive the formal reading, enter a not guilty plea,
Vamos a declararnos no culpable.
and ask that this remain set on the January 8th
Se
docket.
ponga la fecha para en enero.
Mr. Diaz, I will see you on January 8th at 9 o'clock.
8 de enero a las 9 de la mañana.
Thank you, sir.
Una pregunta.
One question.
Yes,
La pregunta que le mandaron una carta también a Leslie Alvarado Gutiérrez.
They also sent a letter to Leslie Alvarado Gutierrez.
That's the same notice. This is just to make sure
Es la
you got
misma
here.
notificación para que usted, para asegurarse que usted llegara acá.
Keep in mind, January 8th at 9
El
o'clock.
8 de enero a las 9 de la mañana.
Ok, gracias.
Madam Interpreter, do you have other cases?
Yes, Johan Rivera Munoz.
Okay, if you want to call that out.
I'm not sure. Johan Rivera Munoz. Is that, should I wait for that?
Someone's walking
Oh,
out.
okay.
It's Thomas's case.
Mr. McKinney?
Judge, this is Mr. Koch's case. I will fill in for right now, and then if he is not guilty,
Vamos a declararnos no culpables.
I'm providing contact information for his attorney, Mr. Thomas
La
Koch.
información y contacto de su abogado, el señor Koch.
We would acknowledge the receipt of a 4-count information,
Hemos recibido esta notificación.
enter a plea of not guilty,
Se declara no culpable.
and ask for this to remain scheduled on the pretrial court date of January
Pedimos
8th.
que esto se haga el 8 de enero.
So I will see you back here on January 8th
Estamos el 8 de enero
at 9 o'clock.
a las 9 de la mañana.
Make an appointment with the public defender and talk to them on the phone, okay?
Defensor público y hablar con ellos por teléfono.
Okay, gracias.
Thank you, sir.
Thank you.
Yes, ma'am.
Judge, I have an interpreter case as well.
Good.
Mr. Arnaldo Vejejo Vargas. I probably messed that all up. He's here in 23 CF 2321.
Good morning, sir.
Good morning,
Or I'm sorry, good afternoon.
Judge, he does speak some English, but he requested the interpreter to make sure that he understands everything fully. We would acknowledge the receipt of a 1-count information
Esta información,
charging the possession of controlled substance.
acusado de tener sustancias reguladas,
We would waive its formal reading,
se renuncia a la lectura formal
enter a plea of not guilty,
y nos declaramos no culpable.
and ask for this to remain scheduled on January 8th at 9 a.m. for pretrial.
8 de enero a las 9 de la mañana para un prejuicio.
Mr. McKinney, has the state given you an offer on that case?
No, Your Honor, not as of yet.
Does the state have an offer for the defendant?
Yes, Your Honor, it's an adjudication of guilt, 18 months probation, $615 in court costs, PD fee, substance abuse evaluation and any treatment, and 36 hours of community service.
Okay, thank you.
Was that with an adjudication or a withhold of adjudication?
Adjudication.
We'll maintain our not guilty plea.
Vamos a seguir no culpable.
I'll see you on January 8th at 9 o'clock. Thank you, sir.
De enero.
I'm gonna go get you.
Mr. Kleins, do you represent Mr. Martinez Soto?
Yes, sir.
Good, thank you.
My name is Scott Kleins. I'm going to be your attorney. Your Honor, this is Mr. Josue Martinez Soto.
Okay, let me interrupt you a second. Mr. Martinez Soto, the public defender only represents you on one of your cases? Do you want Mr. Kleins to represent you on your two other cases?
Yes, that's fine.
Okay, I do appoint the public defender to represent Mr. Martinez Soto in all three of his cases.
Good catch, Your Honor.
No, Madam Clerk caught that.
Well, good catch, Madam Clerk.
Thank you.
Your Honor, has there been informations filed on those other two cases?
Yeah, they should all be attached.
The shelf, okay. We will acknowledge receipt in 2228, Your Honor, of a two-count information, charging one count of pawnbroker transaction fraud, one count of petty theft, in 23 CF 2229, two-count information, exact same charges, and in 23 CF 2290, that's the case that I have, that's dealing in stolen property by trafficking and petty theft. In all three of these cases, we will waive the formal reading and enter a not guilty plea, and ask that these remain set on the January 8th docket.
Mr. Martinez Soto, I'll see you back here January 8th at 9 o'clock. Make sure that you make an appointment with Mr. Kleins and talk to him before that date. Thank you, sir. Okay, thank you. Mr. Nopes?
Well, there was some conflict, so I got appointed on the 9th.
Okay.
Judge,
I was offered probation 6 months, just 2 days ago, and I wasn't sure what the turnout was for today, for an even 45 days in, but I will gladly accept the probation for misdemeanor, if we
well,
could.
so that's the confusion, Judge. He's got a misdemeanor case, and I guess they offered him probation yesterday. I
Yes.
think it's when it was, because Tricia Graham approached me yesterday and told me that. I don't know what the state's offer on this case is.
Why don't we ask them?
Yes, ma'am.
Mr. Nopes? Yes, ma'am.
The state's offer is adjudication of guilt, 18 months probation. The court is going to reserve restitution, 515 in court course, and
PD fee is the one? PD fee?
and the PD fee of $83.72.
No.
Judge,
That's the PD fee.
Nice.
What is the adjudication?
I'm so
Adjudication is what? Guilty
It's
or
an adjudication
withholding?
of guilt, yes.
sorry. Yes, Your
So
Honor.
that 8372, I believe, is the cost of investigation for Niceville PD.
Yes.
how much?
Okay,
It's 8372, I'm sorry to talk.
You're fine.
cost of investigation.
Judge, he indicates he wishes to accept that.
Okay. Yes, sir, if you'll raise your right hand.
Sure.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. If you'll please state your full name.
Jeremy James Whitfield.
Mr. Whitfield,
He's going to.
did you understand what the state offered?
Yes, sir, I do.
Do you understand that if I accept your offer, or if I accept the plea, that you'll be waiving your right to a trial by jury?
Yes, sir.
Okay, do you have any questions for the court, your attorney, or the state?
I don't.
Okay. Have you ever been adjudicated guilty of a felony before?
Yes, sir.
Okay. Mr. Whitfield, I do accept your plea. You're adjudicated guilty. You're sentenced to 18 months probation. The court does award restitution, but reserves jurisdiction to determine the amount of that restitution. You need to pay the court cost, $150 public assistance fee, $40 per month cost of supervision, $83 $1,000,000.72 cost of investigation.
Okay.
Thank you, sir. Good luck to you.
Count
Thank
two,
you.
just time served since it's a misdemeanor.
Time served on count 2?
Yes, Your Honor.
Okay, yes, ma'am. Thank you.
I think his misdemeanor case is holding him, so I'll text Ms. Graham and tell her.
Okay. Thanks, Mr. Noakes. Rodney Montgomery, 23 CF 2258. Hello, Mr. Montgomery. Good. Please, if you'll come to the lectern. Okay, to the state, it shows out-of-state fugitive.
Your Honor,
Yes, sir.
I was told by the jail that he had been picked up from, were you Alabama or Mississippi?
I was in Alabama.
They picked you up and transferred you there?
Yes, sir.
Okay, so at this time, Your Honor, the state would dismiss the fugitive from Russia's charges.
Mr. Montgomery, no downside to you for that. Your case number 23 CF 2258 is dismissed.
Okay.
Thank you for showing up.
Yes, sir. Thank you and God bless.
Yes, sir. Thank you. You too. Angel Moore is next. 23 CF 2144. Hello, Ms. Moore. Does the state have an offer for Ms. Moore?
Your Honor, at this time, the state is going to no pros the case due to the statute of limitations.
Okay. Ms. Moore, your case is dismissed.
Thank you.
Thank you, ma'am. Shyninia Perry, 23 CF 2282. Does the state have an offer for Ms. Perry?
Your Honor, our offer is adjudication of guilt, 1 year, 6 months of probation, 515 of court costs, 48 hours of community service, no trespass at Dillard's, anti-theft course.
Okay. Ms. Perry, have you ever been adjudicated guilty of a felony?
Yes, I have.
Okay. So you have the right to an attorney. If you can't afford one, then I can appoint one for you. You have the right to represent yourself, accept the state's offer. You have the right to a trial by jury. What would you like to do?
I would like for you to appoint me an attorney.
Okay. How much money do you make per month?
Actually not working at the time.
How long have you been unemployed?
I'm sorry. For about a year.
Okay. I do appoint the public defender to represent you. Mr. McKinney's approaching on your right.
Hi there.
Hi.
Your attorney's name is going to be Mr. Thomas Koch. That's his contact information. Judge, for Ms. Perry, we acknowledge the receipt of a one-count information, waive its formal reading, and enter a plea of not guilty. We would ask for this to remain on the pretrial court date, which is scheduled for January 8th at 9 a.m. I have provided Mr. Thomas Koch's information to her as her attorney.
Thank you. So your homework is to get in touch with your attorney before January 8th, and I'll see you back here January 8th at 9 o'clock.
All right, thank you.
Thank you, ma'am. Sabrina Silva. Sabrina Marie Silva. I don't see Miss Silva. She is an inmate? Okay, you want her out here? Thank you.
Can I have a red 48, please?
Ms. Silva. So to the state, it shows out-of-state fugitive.
Okay, I'm gonna lower it for you.
Your Honor, is she contesting the,
You don't have that in California.
she is?
No, I understand your question.
Okay.
Ms. Silva,
Hi.
what state's trying to get you? Do you know?
You know what? California, sir.
Okay. Are you contesting them coming to get you?
Am I saying that it's okay for them to come?
Are you saying, no, it's not, and you want to have a case here?
Well, how am I gonna have a case here, sir, if I didn't break the law here,
Okay.
right?
But, well, because we have comity,
Okay.
which is each state recognizes the laws of each other state and helps enforce those.
Right.
So that's how
Okay.
it's enforced between different states. If you want me, Ms. Silva, I'm concerned that you're going to say something about your case that may hurt your case. If you're contesting being taken to California and you can't afford an attorney, then I'll appoint one for you.
Yeah, let's do that.
Judge, may I have just a moment as a friend of the court?
Certainly, yes, sir. This is Mr. McKinney. He's a public defender.
Did she sign a waiver?
There's no waiver.
I'm checking to see if,
But yeah, of course I'm okay with it, yeah. Tell them to come get me.
Judge, it sounds like she is perfectly okay with California coming to get her, but they have not done so, which is why she's currently with us in court.
Right.
Okay. To the state?
Isn't there like a waiver of extradition that she needs to sign?
it's been signed.
Right.
She signed it back on October 2nd, or October 1st, rather.
The
Okay.
30 days been up, you know what I mean?
Yes,
So, like, I
ma'am.
don't
You've been
underst-
here a long time.
I don't understand why I'm still here, Judge.
Understand, it's because California hadn't come and gotten you.
Right.
To the state?
Right.
I mean, Ms. Silva wants an attorney.
This is a weird mechanism. This is a weird situation to be in.
Exactly.
It is, and I think Ms. Silva's best interest would be served by her having a separate attorney. So, Ms. Silva, I do appoint, well, how much money do you make per month?
Sir, I'm unemployed now.
Okay, how long have you been unemployed?
Since probably I got out of prison like 2 years ago.
Okay, I do appoint the public defender to represent you,
Okay,
because
cool.
they'll be the only ones that can unravel this and advocate for you.
Judge, and I am providing contact information for Mr. Koch. This is going to be his case. I will fill him in on
He's walking in the door now.
what's going on in the courtroom.
Okay.
But we will check on this quickly to see what's going on with California, reach out to the state to see if we can reach a resolution very quickly. Very
Silva.
quickly, meaning probably within about a week.
So Mr. Koch will come see you in the jail.
Wait,
okay?
wait,
And then
wait,
I'm
wait,
just
wait.
gonna.
No.
Should I set this
Is there
for
any way
a-
we could just sentence me? Look, I'm down to
No,
do some
ma'am.
time. Look, check it out.
You can't plead it.
We can't send it, this isn't,
This is only.
a fugitive from justice isn't technically a Florida statute.
Please.
So it's not like we could sentence her on this charge.
When do you want to, do we just want to set it for a control date, a month out?
It's not going to happen today.
I think that'd probably be the
Okay, let's do
best, because I know that the state's going to be incredibly busy preparing for trials over the next week, so I would say probably a month out, but we'll try our best to make sure that we can facilitate whatever communications needed between
Okay,
California and
let's do
us.
that.
I know
Okay.
when there's been issues like this in the past, since there's no information that can be filed, because it's not technically a charge, it just gets set for another felony plea day as the control date.
Okay.
I would ask for the next felony plea day scheduled for Ms. Silva.
I mean, the latest one we have in December is the 21st.
Can we just do the very next one?
The very next one is next Wednesday.
We'll do our absolute best to
If we're
get that
unable to reach a
handled.
resolution by then obviously we can keep it on track, but I'd like to try to bring
Okay.
this in for a resolution.
So next Wednesday.
That
Ms.
works.
Silva, I see you next Wednesday, okay? The
Okay.
day before Thanksgiving.
Thank you, Judge Brown. Have
Thank
a
you,
good
ma'am.
day.
You too.
Good day, everybody.
Reach out to California, like I said.
Kyle Villa, 23 CF 2149. Hello, Mr. Villa. Does the state have an offer for Mr. Villa?
I was still writing my notes on Ms. Silva.
Kyle Vincent Villa.
It's 53 on the docket.
He's 52 on my docket.
Your Honor, at this time, the state's offer is an adjudication of guilt. It's going to be either 1 year, or I'm sorry, 6 months of community control followed by 2 years of probation, $615 in court costs, and a public defender's fee if applicable.
Okay.
And, I'm sorry, a substance abuse evaluation, any treatment recommended.
Yes, ma'am. Is that?
Judge, if I may inquire of the defendant, Mr. Villa, would you be interested in drug court?
Pardon?
This is Kyle, not Travis.
Oh. Hold on. Oh, wow, there's 2 Villas. Okay, hold on. I disregard that offer. I'm sorry, Your Honor.
Okay.
I did the same thing.
All right, I'm sorry. Your Honor, for Mr. Kyle Villa, it is a withhold of adjudication, 24 months of probation, $615 in court costs, public defender's fee if applicable, but as of right now, there's no attorney, and then 24 hours of community service work. We would reserve on restitution for 90 days.
Okay.
And
So,
no
Mr.
trespassing at Walmart. I'm sorry, Judge.
Thank you. So, Mr. Villa, have you ever been on probation before?
No, sir.
Okay.
That'd be my,
Do you want me to appoint a public defender if you qualify financially?
yes, sir.
How much money do you make per month?
As of 1 November, I only work seasonally. I'm currently unemployed. Up until then, it was 3 to 5 a month.
3 to 5 what?
1,000 per month.
Okay. You may not qualify for the public defender making that amount. If you'll fill out a financial affidavit at the clerk's office, or we can hand you one here, turn it into the clerk's office at the end of the hall. If the clerk, this is important, so listen, if the clerk says you don't qualify, you can appeal it to the judge, because we have a little more discretion than the clerk does. So when you fill it out, load it up if you've got child support or whatever it is, because the court may look at that and have more discretion, okay? So
Understood.
I'm not appointing the public defender at this time. You're charged with grand theft, $750,000. More than that, less than,
Wait, I just want to make sure that was $750.
thanks, $750.
Very different charge.
And less than $5,000. And so that's the information, that's the charging document that they handed you. And your next hearing on that case is January 8th at 9 o'clock. But I'm looking at the paperwork that I was handed Judge Schlechter on November 2nd to the state, looking at the time of the alleged offense. In our case, what was the date of that?
Hold on one moment, Your Honor. Sorry, I'm pulling that up. I believe that it was on September 20th of 2023.
Okay.
So you're asking about the circuit court case when the arrest date, or?
When the incident was?
23 CF 2149.
Yeah, the incident occurred September 20th of 2023.
Okay, because I've got, okay, this is for a different time. Oh, for first appearance. Okay, but this is this case? No, that's 20 2023, it's got 12194. I don't think that's a case number. Maybe that's y'all's number.
That's our office.
Okay. Okay. Mr. Villa, if you'll look, let me just show you one page of that. This is an arrest report from a different date. If you'll just look at that one page to know what we're talking about, and then I'm going to ask the state to look at it. Because I need to address a bond with you on that alleged crime. Mr. Vieira, I wouldn't say anything about your case at this point. Okay? If you'll show the state. Rachel, please.
Are you still reading, Judge?
Okay.
That's a David case. I'll pull it up.
So,
Mr. Villa, let me ask, hold on. Mr. Villa, how long have you lived in the area?
I moved up to Funiac Springs.
How long have you lived in the Panhandle?
Since I've exited the military in October 2019.
Okay.
And then I permanently established here, it was March 2020.
Okay. Okay, so hold on. What, another judge, instead of giving you a bond and telling the sheriff to go arrest you, they told the sheriff to go arrest you, bring you before this court, but before they arrested you on that, you're here. So let's talk about.
Okay.
And the state may request a bond. I need to set a bond for that case.
Understood. So that.
Your Honor, I think the state would be okay with a $2,500 cash professional bond on this,
Okay.
on this new.
Understand. Mr. Villa, would you be able to give a bail bondsman $250 to bail out?
Yes, sir. I may.
Okay. Then that is granted. So I'm setting your bond at $2,500 cash or professional on that new charge. So
Yes, sir.
they'll take you into custody, but then when you post that bond, they'll let you out. I'll see you back January 8th at 9 o'clock.
Yes, sir. Your Honor, am I able to pay the bond right now?
No, you'll have to go through the booking system first.
Yes, sir.
Thank you, sir.
File it, and there's no active case, there's no case for it. They would, yeah.
Just make sure he's not in limbo forever, waiting on that. Okay. Good, okay, thank you. Jesse Vincent. Jesse Leighton Thomas Vincent. Inmate.
He's an inmate, Judge.
And I think that's the last pro se. Mr. Vincent? Rachel, Mr. Vincent, thank you. Well, Mr. Vincent, if you'll just come to the lectern.
This is Mr. Vincent.
Yes, sir.
It shows there's no attorney on this docket. However, Mr. Vincent is represented by the public defender, I believe, with 2 cases in front of Judge Ketchel.
Okay. Mr. Vincent, do you want the public defender to represent you in this case?
Yes, sir.
I do appoint the public defender to represent you in this case also.
Judge, for today, we would acknowledge the receipt of a 1-count information, enter a plea of not guilty. But I believe that the state, in learning that he's got cases in front of Judge Ketchel, may be seeking to transfer that to Judge Ketchel's division since those are the lower case numbers.
Right. So, Mr. Vincent, just for today, I'm putting you on my docket on January 8th, but again, you'll probably be transferred to Judge Ketchel's docket, okay? But the public defender will come see you on all your cases.
As soon as they make a decision, they're probably going to end up in front of Judge Ketchel for all your cases.
Thank you, sir. Yes, sir. Mr. Snell?
We were just dealing with 23 CF 2201, is that the case number we're talking about right now?
Mr. Vincent?
This is Jesse Vincent, case
Okay,
number
we're on
23,
54. Okay,
20 CF 2347.
perfect. I want to make sure I had the right one.
Good.
Thank you.
Thank you. Thank you, Mr. Vincent. Mr. Nopes?
Mr. Benson?
Who do you represent, Mr. Nopes?
I got 2 that are inmates, LaBello and...
They're on the 2:30 docket.
Okay.
Oh, that's fine. I mean, it's up to you, Judge.
No, let's get these folks out
Sure,
first.
absolutely.
Okay, I didn't know if you had anybody left on this docket. Okay, then to the PD. Folks in the gallery first, if you can.
Joseph Cross.
Joseph Sherman LaCrosse, 23 CF 2275. I don't see Mr. LaCrosse. Was noticed for 1:30, it's 2:06. What does the state seek?
Capias, Your Honor.
A capias will be issued, and the first appearance judge will determine the bond. That means that they'll arrest Mr. LaCrosse, bring him before the court, so we appreciate y'all being here.
Cameron Ladner.
Before you leave, I'm going to put this file on that rail, and you walk on the other side of the rail and write your phone number on it.
Hello, Mr. Ladner.
Hello.
Your Honor, this is Mr. Ladner. We will acknowledge receipt of a 2-count information, waive the formal reading, enter a not guilty plea, and just ask that this remain set on the January 8th docket.
Mr. Ladner, I'll see you on January 8th at 9 o'clock.
Yes, sir.
Thank you, sir.
Write your name. Please. Neil Matthews. Mr. Matthews is present and approaching, Your Honor. We will acknowledge receipt of a 1-count information, waive the formal reading, and ask that this remain set on the January 8th docket.
Okay. Mr. Matthews, I'll see you January 8th at 9 o'clock.
Yes, sir.
Thank you, sir.
All right, man.
Thank you.
Yep. Yep, that's all I needed. Elaine McPhee.
Of course.
Ms. McPhee is present and approaching, Your Honor. While she does that, we will acknowledge receipt of a 1-count information, waive the formal reading, enter a not guilty plea, and ask that this remain on the January 8th docket.
Okay. Ms. McPhee, how are you doing?
My what?
How are you doing?
Much better.
Good, good, I'm glad. I'll see you back here on January 8th at 9 o'clock. Stay in touch with Mr. Kleins, okay?
Okay.
Thank you, ma'am. Thank you, sir.
Absolutely, thank you. Next, I have Ray McMullen. Ms. McMullen is present and approaching, Your Honor. We do have a 3-count information. We will will waive the formal reading, enter a not guilty plea, ask that this remain set on the January 8th docket. If there is an early resolution in this particular case, we'll advance it on the docket.
Good. Ms. McMullen, if the state offers you something that you want to accept before January 8th, to avoid about 300 people, you can enter that plea before, okay?
Okay, thank you.
Thank you, ma'am.
Nice, nice. Nora Mullins?
I'm saying I have cooties, David. I have cooties.
Please silence your cell phones.
I have cooties.
Ms. Mullins. My name is Scott Kleins. I'm going to be your attorney. Okay? Your Honor, this is Ms. Mullins. We do have a one-count information. We will waive the formal reading, enter a not guilty plea, ask that it remain set on the January 8th docket.
Ms. Mullins, I'll see you on January 8th at 9 o'clock. Stay in touch with Mr. Klein.
Yes, sir.
Thank you, ma'am.
Jason O'Rillian?
Scott. Call Nickerson too.
Jason O'Rillian.
It's 2:10. It was noticed for 1:30. What does the state seek?
Your Honor, the state would seek a capias.
A capias will be issued for Mr. Aurelian, and the first appearance judge will determine the bond.
Your Honor, I have two other cases kind of out of order. The first would be Thomas Moses. This is a fugitive from justice.
Oh, yeah. Your Honor, on this one, I contacted the jail, and they confirmed that he was extradited, and so at this time, the state would dismiss the fugitive from justice charge.
Okay, so Mr. Moses' case is dismissed.
And then the last one I have out of custody would be Gary Nickerson.
Your Honor, we received the word that Mr. Nickerson unfortunately is deceased, and so at this time, we will be dismissing the case.
Okay, that case is dismissed.
That's all I have out of custody.
Okay, thank you. Mr. Tkach?
Yes, Judge. First one to call is Johan Rivera Muniz.
We already did Mr. Muniz. We did him without you.
Okay, thank you. Judge, next case, Gary Rawlison, who's present and approaching, Judge.
Thank you.
And this is 2023 CF 2199. Yes, Your Honor. At this time, we'll enter a not guilty request to be placed on the January 8th, and I'm handing my client my business card, Judge.
Thank you. January 8th at 9 o'clock. I'll see you then. Stay in touch with Mr. Koch.
Yes.
Thank you, sir.
I think I'm doing it. I just said 1-8, actually.
Judge, next, James Sykes. This is 2023 CF 2249. And information has been filed, Judge. We need to enter not guilty, waive formal reading, and ask to get set for that January 8th, Your Honor.
Okay. Mr. Sykes, I'll see you on January 8th at 9 o'clock.
Yes, sir.
Thank you, sir.
And Your Honor. Your Honor, that's all my out of custody.
Thank you. Mr. Kleins?
Judge, I have Loretta Tapper. Tapper?
Hello, Ms. Tapper.
Hi.
Judge, Ms. Tapper is with us in 23 CF 2251. I gave you my copy, right? Okay. We would acknowledge the receipt of a two-count information, waive its formal reading, and enter a plea of not guilty. This is scheduled for the 8th of January at 9 a.m. for a pretrial. I believe Ms. Tapper is going to come see me at my office. We may be able to resolve this earlier than that.
Good.
But absent that, she would need to be back in court on January 8th at 9 a.m.
Thank you.
Thank you, Ms. Tapper. I'll see you then.
Jason Wilson.
Jason Wilson Yes.
Mr. Wilson is approaching from the back in 23 CF 2173. We would acknowledge the receipt of a one-count information, waive his formal reading, enter a plea of not guilty. Judge, this is a driving case. He's working on making sure his license is current, hopefully before we get to January 8th, because that may impact where we go with it.
Good.
But for today's purposes, we'll enter the plea of not guilty and ask to stay on 1/8.
I'll see you on January 8th at 9 o'clock.
Thank you.
Thank you, sir.
Yeah. work on that real quick. Judge, I also have Travis Villa in the courtroom. However, I'm writing up a plea agreement. If we could recall that in a few minutes.
Okay, yes, sir. Rachel, you're calling the docket.
Jerry Mays, Mr. Klein.
And to the state and to the attorneys, there's some problem with Zoom. It is not working very well, so if there's somebody that's appearing via Zoom, you may want to let them know for if they're going to come at 2:30.
And Your Honor, just for the court's awareness, we are stipulating to the motion for bond that Mr. Kleins has filed for his client.
Okay, thank you.
Your Honor, this is Mr. Mays. He is on today's docket in 23 CF 2367. We will acknowledge receipt of a one-count information, waive the formal reading, enter a not guilty plea, as Mr. Gomez just informed the court. That bond motion that we filed only dealt with 21 CF 1932, so Mr. Mays is still going to have a cash or professional bond on this case that he's before the court for today. But in any event, I would ask the court to put both of these cases on the January 8th docket.
Okay, but there's a stipulated bond motion on what case and what's being changed?
21 CF 1932. So the situation is, Your Honor, that Mr. Mays was out on bond in that case, and then in August, he was arrested on a new law violation, and at first appearance, that bond was revoked. The new law violation was dismissed about a month ago, and so that's the basis for the request for the bond reinstatement.
21 CF 1932, the bond's reinstated.
And it was originally an ROR bond.
Okay.
Yes.
So an ROR bond.
And we'll provide the court an order for tomorrow morning.
And just for the record, the state's stipulating because the new law that was the basis of the VOP was dismissed.
Understand. Is Mr. Mays being held for any other case?
Well, he's being held on this particular case, the 23 CF case. There is a $2,000 cash or professional bond. He's aware he's going to have to post that if he gets out. But as far as I know, he's not being held for any other reason.
So, Mr. Mays, I'll see you on this case on January 8th, okay? Thank you, sir.
Do you want me to notate the motion to reinstate bond for the other case? Do you want me to notate that on this minute sheet?
Please, if that way, if he somehow posts the other bond today, hopefully he can get out before the court has an order.
Thank you.
Your Honor, Mr. McKinney is before the court for two different reasons. Today, in 23 CF 2288 is his arraignment. On that particular case, Your Honor, there was a two-count information. We will waive the formal reading, enter a not guilty plea. He is also before the court in 23 CF 1857 on a motion to reinstate bond. If the court would let me take some brief testimony.
Please, Mr. McKinney, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do, Your Honor.
Thank you, sir. You can put your hand down.
Mr. McKinney, if you're released on bond, where are you going to live?
15 Domains, almost right here. It's 134 Fading Avenue, Lot 4.
Is that different? That's different from your address that you gave me in the motion. Is that a new address?
That's my old address.
That's your old address? So you used to live at 705 Woodlawn Avenue?
Yes, sir.
And now you're going to be living on Fetting?
Yes, sir.
What do you do for a living?
I'm on the Social Security disability.
How long have you been receiving disability?
Since September 2010.
How long have you lived in the area?
All of my life, sir.
If you are released on bond, is it your intention to come back to court and answer to these charges?
Yes, sir, Your Honor.
Okay. If the court granted the motion to reinstate bond, would you have any objection to the court putting you on pretrial services, so you would have to report while you're out on bond?
No, sir, I wouldn't.
Okay. You having any issues with your neck?
No, sir.
No? Okay. I don't have any other questions.
To the state, any questions for Mr. McKinney?
No questions, Your Honor.
Okay, thank you. Argument, Mr. Kleins?
Your Honor, we are asking the court, so what happened is Mr. McKinney was out on bond in this 1857 case. He picked up these new charges at the beginning of October in 23 CF 2288. Mr. McKinney denies the substance of the allegations in the 2288 case. I have not had a chance to take depositions in that case just yet. The allegation essentially from our perspective is that Mr. McKinney was in a car that may or may not have had permission to be in. He strongly disputes that, and I believe that if he's not related to the owner of the car, then he's at least personally known to this person.
His nephew.
You're his nephew?
Yes, sir. It's my Uncle Riley. And Mary Cabello. And my Uncle Riley is supposed to go to the state attorney's office today, resolve that. He's supposed to be to pay for the door panel on his car. It was a total mistake, misunderstanding.
So we would just ask that the court exercise its discretion, reinstate the bond in 1857 while we handle this matter.
To the state.
Your Honor, the state would respectfully request that the bond remain revoked in 23 CF 1857, as they've stated. 1857 occurred, I believe, as recently as August of 23, and then he's released out on bond, and then 2 months later commits a new law violation. The state would love to say this is the only time that Mr. McKinney has been involved in the criminal justice system. However, a glance of his prior record, multiple POPs, multiple burglaries, multiple petty thefts, contempt of court for violation of injunctions, resisting without violence, felony battery, another petty theft, third or more felony petty theft, more batteries, more trespasses. I mean, it is quite an extensive record with somewhere in the neighborhood of around 40 priors. Your Honor, it's clear that this defendant is not amenable to following the law. Given this, we would respectfully request that the bond remain revoked in 23 CF 1857 pending the resolution of these cases.
Thank you. Mr. Kleins, finally, anything else?
Just at this point, Your Honor, these are allegations only. Everything Mr. McKinney is currently facing has not been tested in the crucible of trial, so to speak.
Yes, sir.
I can tell the court that Mr. McKinney strongly has protested his innocence, but other than that,
Okay.
Mr. McKinney just wants to relate that he believes that the alleged victim in the newest new law violation is desiring to press charges. I can't speak to that.
To not press charges.
Not today.
Right.
But my girlfriend Mary at the state attorney's office.
I don't know. I haven't talked to this individual yet. Mr.
Right.
McKinney wants the court to know that.
Understand. Mr. McKinney, respectfully, your motion to reinstate bond is denied, so you'll remain in jail. The public defender will come see you there.
Thank you. Talk to you, see if we can get something worked out in the month of December. Okay. Next court date is going to be January 8th. Your Honor, if we could leave these on for January 8th, if we get some kind of an early disposition, we'll certainly advance this on the docket.
All the cases, January 8th. Yes, sir.
Yes, sir.
January 8th?
Yes. All right, but I'll come talk to you. See if we can-
Next is Michael Myers.
Thank you. Hello, Mr. Myers.
Hello, how you doing, sir?
Good, how are you?
I've been better, Your Honor.
Yes, sir.
Do you have any questions?
No, thank you very much. Yeah.
I'm going to have you sign up, get in that.
And now,
reading? I think it's 48 hours, but I don't know if there's a hard date. Your Honor, Mr. Gomez is signing a plea agreement right now. Mr. Myers is going to be entering a plea as charged. The agreed-upon disposition is that Mr. Myers will be sentenced to time served, be assessed $615 in court costs, $150 in public defender fees.
I'll email that with you.
The $150 in public defender fees, he's previously been adjudicated. And if Mr. Myers can just go ahead and date it. Today's 11/16.
Score sheet needs to get to the court on that one. And you need to make sure that Scott stipulates to its...
Mr. Myers, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can put your hand up. Mr. Myers, did you read the plea agreement?
I did, yes.
Do you understand it?
Yes, sir.
Did you sign it?
I did.
Mr. Myers, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. You'll need to pay the court costs, $150 public defender's fee. How long do you want to pay those amounts before they go to a civil lien or
Can you give me
judgment?
3 months, Your Honor?
Yes, sir. If you fail to pay them within 3 months, then they'll go to a civil lien or judgment.
Okay.
Thank you, sir.
Thank you, Mr. Klein. Thank you so much.
Yes, sir. Good
If we can
luck.
find a bailiff. He'll need fingerprints.
Oh, yeah, they got it.
Yes, ma'am.
You got Millicent? Yep.
Donald Nelson?
Thank you.
I'd recommend we just enter a not guilty plea. I'll come to the... Your Honor, if we could pass Mr. Millicent briefly.
Okay, Mr. Millicent, I'll see you later this morning, or this afternoon.
You on probation, or you want to take the time, sir?
Son Wynn is next.
Thank you.
All right, I'll talk to you in a minute. Your Honor, this is Mr. Sun Win in 23 CF 2302. We do have a one-count information. We will waive the formal reading, enter a not guilty plea. Ask that this remain set on the January 8th docket.
Okay. I'll see you on January 8th at 9 o'clock, okay?
Okay.
Thank you, sir.
Emery Parrish is next. Do you have some out?
I do.
You can. Go ahead.
Judge, I have Brentley Wright in the courtroom.
Okay. Thank you.
Mr. Brentley Wright is here in 23 CF 2340. Wright with a W. We would acknowledge the receipt of a two-count information, waive its formal reading, enter a plea of not guilty, ask for this to remain on January 8th for pretrial.
Okay. Mr. Wright, I'll see you back here January 8th at 9 o'clock. Stay in touch with Mr. McKinney.
Yes, sir. What's that? The Walton case? No.
How about Emery Parrish with Mr. Cottage?
Okay, thank you.
I'll take the plea form. Judge, if I have a moment to sign the form.
Yes, sir.
Thank you. If you sign right there, dated 16th. And I know we just talked. Okay.
Mr. Parrish, if you'll raise your right hand.
Yes, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down.
Thanks, Judge. My client will be entering a no contest plea, Your Honor, and this will be adjudicated guilty, be 6 months drug offender probation, which will have the curfew from 7 p.m. to 7 a.m., be followed by 30 months of standard probation. Court costs are $1,582, $250 for defense costs, 24 hours community service, no contact with Eugene Daleski, and then complete the anger management class, Your Honor. If I may approach with the plea form.
Yes, sir. And then $40 per month cost of supervision, correct?
Yes, Judge.
Okay. Thank you. Mr. Parrish, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Parrish, I do accept your plea. You're adjudicated guilty. You're sentenced to 6 months drug offender probation, followed by 30 months of traditional probation. Your curfew will be 7 p.m. to 7 a.m. while you're on drug offender probation. You need to pay the court costs $1,582, $250 in public defender's fee, perform 24 hours of community service work, have no contact with the victim, enter and successfully complete the anger management course, pay the $40 per month cost of supervision. Yes, sir.
Judge, I apologize. I spoke with my client. There is another condition, the substance abuse evaluation. If I could have that form back, Your Honor.
Mr. Parrish, do you agree to that, the substance abuse?
I apologize. I do have a plea form. I'm just going to provide a score sheet.
So you'll need to submit to a substance abuse evaluation within 30 days from today. If any treatment's recommended, begin that within 60 days from today.
Could I get a, okay, I won't get out until December 11th because I'm on a 60-day purge.
Okay, good. Then all these time periods will start after you're released.
Yes, sir. Thank you.
Thank you. Yes, sir. Thank you. Thank you, sir. Thank you, Mr. Parrish.
Yes, sir.
Cameron Perry is next.
Yes. If I just have a brief moment, Judge.
Yes, sir. They'll love scanning that in.
Yeah. Yeah.
Yes, sir. Thank you, Judge.
Yes, sir.
This is Mr. Perry in 23 CF 2319. This will be a change of plea, Your Honor, of no contest. For count one, be a withhold adjudication, 2 years probation, no objection from the state attorney for early termination after 1 year if all conditions are satisfied. Successful completion of the Project Hope 12-month residential rehabilitation program. Will be the substance abuse evaluation within 30 days and any recommended treatment within 60 days. $615 in court costs, $150 for defense costs, the $40 per month cost supervision. And for count two, Your Honor, it is credit for time served adjudicated on that count. May I approach, please?
Yes, sir. Mr. Perry, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. Mr. Perry, did you read the plea agreement?
Yes, I did.
Do you understand it?
I understand it.
Did you discuss it with your attorney?
Yes, I did.
Did he answer all of your questions?
Yes.
Are you satisfied with his representation?
I
I am satisfied, yes.
Did you sign the plea agreement?
Yes.
Mr. Perry, I do accept your plea. You're adjudicated guilty in count 2. You're sentenced to credit for time served. In count 1, it's a withhold of adjudication, 2 years probation. However, your probation will automatically terminate at the 1-year mark if you've successfully completed all the terms of your supervision and haven't committed any new law violations. You need to enter and successfully complete the inpatient or Project Hope. Submit to a substance abuse. Mr. Koch?
Yes, Judge.
Koch, won't they do the substance abuse evaluation in Project Hope?
They will, Judge.
I'll just say it this way. You'll need to do the substance abuse evaluation within 30 days, begin any treatment within 60 days. However, if they do that in Project Hope, that will fulfill that obligation.
Thanks, Judge.
You'll need to pay the court costs, $150 public defender's fee, $40 per month cost of supervision, but that $40 will be waived while you're in Project Hope. Okay?
Thank you.
Thank you, sir. Good luck to you.
Is it a bars
Thank
to
you.
bed?
Yes.
Thank you.
That's all yours. Best of luck, all right? Thank you. Yep, you're welcome.
Courtney Kayasaki.
Yes, thank you, Judge. We're here in 23 CF 2316. Information has been filed, Your Honor. We'll enter not guilty, waive formal reading, and ask to get this set on the January 8th pre-trial.
Okay. I'll see you back here no later than January 8th, okay? Thank you, ma'am.
Next is Megan Robb.
I'll take that. And Judge, if I just may have a moment just for
Yes,
the
sir.
signature. You sign right there for me. Then 11/16. I know we just talked. Any questions?
If you'll please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, ma'am. You can put your hand down. We'll both wait on the paperwork.
Thank you, Your Honor. And this will be a change of plea. Be entering a no contest. Be adjudicated guilty with 36 months of probation, 515 in court costs, 150 for defense costs. There's 100 hours of community service. Order and reserve restitution for 180 days. $89.45 cost of transportation. Be no contact with Alexander Bolin, and gainful employment or 5 job applications per week, Your Honor. If I may approach, please.
Yes, sir. Thank you. So did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes.
Did he answer all of your questions?
Yes.
Are you satisfied with his representation?
Yes.
Did you sign the plea agreement?
Yes.
Have you ever been adjudicated guilty of a felony before?
Yes.
I do accept your plea. You're adjudicated guilty. You're sentenced to 36 months probation. You'll need to pay the court costs, $150 public defender's fee, $40 per month cost of supervision, perform 100 hours of community service work. The court does award restitution, but reserves jurisdiction to determine the amount of that restitution if the state files a motion or a petition within 180 days from today. You need to pay $89.45 in the cost of transportation. Have no contact with Alexander Bolin, B-O-L-I-N. You will need to obtain gainful employment or do 5 job applications per week. Thank you, ma'am. Good luck to you.
Thank you.
Best of luck.
Thank you.
Do you have any questions for me?
No, sir.
Judge, this is Misty Woodhams before the court. She is here today in 23 CF 2255. She's also on next week's arraignment for 23 CF 2382. The state has filed informations in both cases. We've reached an agreement in both cases. Ms. Woodhams wishes to enter a plea of no contest as charged in both case numbers for a concurrent 36 months probation. Adjudication will be withheld. Special conditions will include substance abuse evaluation and treatment to begin within 30 days. The evaluation within 30 days, treatment to begin within 60, random urinalysis, reserve over the issue of restitution, no trespass at Atlanta Fashions. Court costs are in the amount of $615, $515 in 23 CF 2255, total of $250 cost of defense. There would be a $40 a month cost of supervision. Ms. Woodhams is going to request that the court consider waiving a portion of that cost of supervision because she does need to get back out on her feet to get back employed. May I approach with the plea agreement?
Yes, sir. Please. Thank you.
Madam Clerk, it does include 23 CF 2382, which is on next week's arraignment docket.
Ms. Woodham, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, ma'am. You can put your hand down. Ms. Woodham, Ms. Woodhams, did you read the plea agreement?
I did, yes, sir.
Do you understand it?
I do.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Ms. Woodhams, I do accept your plea. Adjudication is withheld. You're sentenced to 36 months probation, and that's concurrently on counts one. On count 1 of each of the cases, time served on count 2. You'll need to submit to a substance abuse evaluation within 30 days from today. Begin any treatment if it's recommended within 60 days from today. Submit to random urinalysis. The court does award restitution, but reserves jurisdiction to determine the amount of that restitution if the state files a motion or a petition. You have no trespassing at Atlanta Fashions. You need to pay the court cost, $250 public defender's fee, $40 per month cost of supervision. However, Ms. Woodhams, how much money do you average making per month?
I make up to $800 a week when I'm working.
Okay. And how long do you think it'll take you to get back up to speed on work?
So maybe 3 weeks, 4 weeks, about a month. I'm helping my mom with a 4-year-old at the moment. She just got custody of her.
Okay. So I'll waive the cost of supervision for the first 2 months, but after that, you'll need to pay it.
Yes, sir.
Thank you, ma'am.
Thank you.
Good luck to you.
Thank you.
Okay, you're going to check in the probation when you get out today.
Mr. Koch.
Judge, I have one out in the audience, too.
Good,
Travis
please.
Villa. Mr. Villa is ready in 23 CF 2201. He is on the arraignment docket. However, we've reached an agreement for a plea as charged. The agreement calls for an adjudication of guilt. He has previously been adjudicated. He'd be placed on 12 months drug offender probation, followed by 24 months of standard probation. Special conditions would include substance abuse evaluation within 30 days, treatment to begin within 60, random urinalysis, standard curfew. We would ask that probation be allowed to manage the curfew based on his employment. I know he does currently work the night shift at Sonic, but I'm going to announce standard curfew and allow probation to maneuver that however they see fit.
6 p.m. to 6 a.m. Yes, ma'am.
Credit for time served for the misdemeanor count 2, $615 in court costs, $150 cost of defense, $40 per month cost of supervision. May I approach?
Yes, sir. Mr. Villa, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Did you read the plea agreement?
Yes.
Do you understand it?
Yes.
Did you discuss it with your attorney?
Yes.
Did he answer all of your questions?
Yes,
Are you satisfied with his representation?
absolutely.
Did you sign the plea agreement?
Yes.
Mr. Villa, I do accept your plea. You're adjudicated guilty. You're sentenced to 12 months drug offender probation, followed by 24 months of traditional probation. You'll need to submit to a substance abuse evaluation within 30 days from today, begin any treatment within 60 days from today. Submit to random urinalysis. You have a curfew from 6 p.m. to 6 a.m. while you're on drug offender probation. That is subject to probation, can change that for work or school purposes. You will get credit for time served on count 2. You'll need to pay the $150 public defender's fee, $40 per month cost of supervision. Thank you, sir. Good luck to you.
Thank you.
And you're going to go for fingerprint and then see probation. Madam Clerk, is there a Monisha Thomas on the docket under my name?
Yes.
Judge, I signed a stipulation for James Owens to come on as the attorney, but I did not see a notice of appearance.
Okay.
And it remains on the docket. I was uncomfortable filing a written plea of not guilty, given that I had signed the stipulation of counsel.
Gotcha. Is Ms. Thomas here?
No, sir.
Okay.
But normally I would expect a written plea of not guilty with a notice of appearance from a
Right.
private attorney.
Why don't we set it for status on, is it Monday that we have?
We have docket day on Monday.
We also have the,
Peer review and miscellaneous in the afternoon next Wednesday.
let's do Wednesday at 9 o'clock for status.
Yes, sir. And Madam Clerk, I also filed a written plea of not guilty for Bernard William, 23 CF 2235, and I saw that he was on the docket. I just wanted to make sure.
It's come off.
Okay.
Good, thank you.
Tanya Slade is next.
Thank you.
Or Mr. Koch.
Thank you.
Yes, Judge.
Slade.
And this is in 23 CF 2177. Your Honor,
Honestly,
you've already signed an order, getting Mr. Ziman to evaluate my client.
Yes,
So
sir.
at this point, if we could enter a not guilty, keep it set for the January 8th.
okay. So Ms. Slade, I'll see you back here no later than January 8th. Okay? Thank you, ma'am.
Next is Justin Price.
Yeah.
Your Honor, if I just have a brief moment.
To the attorneys for the 2:30 hearings, is anybody supposed to appear via Zoom?
Do you guys have anything to
Wow, that's awesome.
I don't believe so, Judge.
Good, because they're having internet problems and it's kicking Zoom out quickly. Thank you. Mr. Koch?
Thank you, Judge. In 23 CF 2345, Your Honor, enter a not guilty, waive formal readings, and keep it set for January 8th.
Okay.
And if possible, Judge, I do have the plea form signed. This is 2 misdemeanor cases that are holding my client with no bond. If I may enter a plea on those charges today.
Okay. Any objection from the state? He wants to enter pleas on 2 misdemeanor charges.
Yes. I got the email from the...
Oh, this was the one you attached.
So, no objection to that?
Okay. Thank you, Judge. And the case numbers are 23 MM 2165 and 23 MM 3734.
Okay, please.
It's going to be adjudicated guilty on...
You don't have to announce it on a misdemeanor,
Oh.
you're good. Thank you, especially when it's not mine. Thank you. Okay. So, Mr. Price, then I'll see you back on my case, on the felony case, no later than January 8th, okay? Thank you, sir.
Is it a written plea agreement?
Ma'am?
Is it a written plea agreement, like it has a judge's signature on it? Or you
Yes,
signed
ma'am.
it?
He signed it.
Okay.
Okay. Right, I agree. Before. Yes, sir.
Yes, Judge, thank you. This is Quentin Purnell in 23 CF 2186. We'll be entering a not guilty, Your Honor. Waive formal reading and just keep it set for the January 8th,
Okay.
please.
Mr. Purnell, I'll see you no later than January 8th.
Yes, sir.
Thank you, sir.
All right, Quentin.
Cruz Reyes is next.
I just have a moment to sign the form, Judge. Sign it right there. And today's the 16th.
Is that 11?
Yep.
What about that court date in May?
That'll be canceled. No? Okay.
Mr. Reagan, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You can put your hand down.
Thank you, Judge.
Yes, sir.
Judge, my client will be entering no contest plea. Counts 1 and counts 3 will be as charged. Count 2 is the lesser included of giving false ID while being detained, and that's Florida Statute 901.36, first-degree misdemeanor, Your Honor. To those counts, it's be adjudicated guilty, 60 days, Okaloosa County Jail. There'll be credit for time served, $270 in court costs, and $115 defense costs, Your Honor, if I may approach.
Yes, sir. Mr. Reagan, did you read the plea agreement? Did you read it?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Mr. Reagan, I do accept your plea. You're adjudicated guilty. You're sentenced to 60 days in the Okaloosa County Jail, and that's to run concurrently, run at the same time between each count. It's also with credit for all time served. You need to pay the court costs, $150 public defender's fee. How long will it take you to pay those fees? About less than $500.
6 months will be okay?
Okay, yes, sir. If you fail to pay it within 6 months, then it'll go to a civil lien or judgment.
Thank you, Judge.
Thank you, sir.
Oops, sorry.
Sean Roberson's next. He
Thank
has
you.
Mr. Cobb, Jason Cobb.
Okay. Hello, Mr. Roberson. Okay, so we're trying to figure out where Mr. Cobb is. Was Mr. Cobb appointed, or is he private counsel? Do we know?
He's court appointed. He was appointed, Your Honor,
Okay.
last week, on the 8th.
Okay. Mr. Roberson, what I'll do is, Mr. Cobb is representing you. I take it that he hasn't gotten in contact with you yet.
No, sir.
Okay. I will enter a denial for you. The reason why you're here, where would Mr. Roberson show up on this docket? Anybody got a number of where he is?
34 on page 11 of my document.
Thank you. The names, I've never seen them as scrambled as they are. Good. Mr. Roberson's case is 23 CF 2358. Reason why you're here are the charges of child neglect without great bodily harm, possession of drugs without a prescription, and narcotic equipment, paraphernalia. I'll enter a denial for you and then set your hearing for Wednesday for a status conference where we can make sure that you and Mr. Cobb get together, okay?
All right.
So I'll see you Wednesday morning.
Okay, thank you.
Thank you, sir. And they gave you the information.
All right.
Good, thank you. Okay, whatever Wednesday is. Yes, sir, November 22nd. Anyone else for the 1:30 docket? Rachel, is that everybody for 1:30?
No, Judge. Colorado was next.
Okay, thank you.
It was a big plea day docket.
It was.
Yes, Judge, if I just have a brief moment.
Yes, sir.
Judge, yes, this is Pablo Salgado. We change a plea, Your Honor. No contest. In 23 CF 2195, count 1, 23 CF 2196, count 1, be adjudicated guilty, 3 years probation, be $40 a month cost supervision, 24 hours community service, maintain gainful employment, or submit 3 job applications per week. There's the 1-year driver's license revocation, $1,030 in court costs, $250 for defense costs, and in 23 CF 2195, count 2, be adjudicated guilty, credit for time served, if I may approach.
Yes, sir. Mr. Segato, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You can put your hand up. Mr. Segato, first off, have you ever been adjudicated guilty of a felon? This is a felony, correct?
Correct.
Have you ever been adjudicated guilty of a felony?
No, Your Honor.
Okay. So do you understand if I accept this plea that you'll be a convicted felon?
Yes, Your Honor.
Do you still wish to enter the plea?
Yes, Your Honor.
Did you read the plea agreement?
Yes, Your Honor.
Do you understand it?
Yes, Your Honor.
Did you discuss it with your attorney?
Yes, Your Honor.
Did he answer all of your questions?
Yes, Your Honor.
Are you satisfied with his representation?
Yes, Your Honor.
Did you sign the plea agreement?
Yes, Your Honor.
Mr. Salgado, I do accept your plea. As to each count 1, you're adjudicated guilty in each case and count. On the count 1s, you're sentenced to 3 years probation. You need to pay the $40 per month cost of supervision, perform 24 hours of community service work, maintain gainful employment, or submit 3 job applications per week. There is a 1-year driver's license revocation. You need to pay the court cost, total of $250 public defender's fee. And I think that's it, Mr. Salgado. Thank you, sir.
Thank you.
Yep.
Thomas Sharp.
I talked to her. Okay. Yes, Judge. I have Mr. Sharp next to me. He has another misdemeanor case in 23 MM 3179. An order has already been signed for the evaluation of my client.
Okay.
So as of now, we'll enter a not guilty, waive formal reading, and keep it set for January 8th.
Okay. Mr. Sharp, I'll see you back here no later than January 8th. It'll be in the afternoon if you're in jail, okay? So I'll see you on January 8th.
January 8th.
Yes, sir. Thank you.
All right, Tom. I'll see you. You're welcome.
Dustin Smith.
Hello, Mr. Smith.
And Your Honor, if I just have a moment just to sign
Yes, sir.
the plea form. Okay, you sign right there. And today is the 16th, 11/16/23.
Mr. Smith, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Absolutely.
Thank you, sir. You can put your hand down.
Judge, I'll read the terms while they sign it.
Please.
It's going to be an adjudication of guilt, 2 years of probation. It'll be court costs and defense costs. I'll get the exact figure, Judge. But there'll be 36 hours of community service, no return to Ronnie's Car Wash.
In other words, no trespass?
Correct, Judge.
Okay.
And I put the address of 6208 Egland Parkway, Fort Walton Beach. While on probation, no possession of alcohol or consumption of alcohol, no possession of any drugs without a prescription, random urinalysis, and random breath tests, Your Honor.
Okay.
And just to be clear, the court costs are $615, defense costs of $150. There is a substance abuse evaluation within 30 days, any recommended treatment within 60. And if I may approach, Your Honor.
Yes, sir. Mr. Smith, I've already sworn you in. Have you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Smith, I do accept your plea. You're adjudicated guilty. And this is as to count 1, so is it time served on count 2?
Yes, Judge.
Okay. Adjudicated guilty, you're sentenced to 2 years probation in count 1, time served in count 2. You need to pay the court costs, $150 public defender's fee, $40 per month cost of supervision, perform 36 hours of community service work, have no trespassing at Ronnie's Car Wash, at that Egland Parkway address, no alcohol or drugs, medication without a valid prescription. You'll need to submit to random urinalysis, random breath test, and submit to a substance abuse evaluation within 30 days from today, and begin any treatment if it's recommended within 60 days from today. Thank you, Mr. Smith.
Thank you.
All right, best of luck.
And we have Timothy Smith.
Thank you.
Judge, if I had just a brief moment.
Yes, sir.
Judge, I have Timothy Smith to my left, 23 CF 2161. At this point, we'll enter a not guilty, Your Honor, waive formal reading if we can keep this set for the January 8th pretrial.
Okay. Mr. Smith, I'll see you no later than January 8th. Thank you, sir.
And I can always get it early.
We're going to recall Donald Nelson, Mr. Klein.
No, they can't be waived, but he'll give you up to a year to pay it. Okay. I need you to sign and date it here. Today is November 16th. Your Honor, this is Donald Millison in 23 CF 2315. Mr. Millicent has reached an agreement with the state to resolve this case. At this time, Mr. Millicent is going to be entering a plea of no contest as charged, 11/16/23. The agreed-upon disposition is that Mr. Millicent will be sentenced to credit for time served. He'll be assessed $615 in court costs, $150 in public defender fees. He will be adjudicated. I did go over with Mr. Millicent what I know about adjudications. However, I did make it clear to him that there's potentially hundreds of different ways that this could impact him. He's aware of that, and he's electing to take this adjudication. He will be adjudicated for the first time.
Thank you, sir.
May I approach?
Yes, sir. Mr. Millicent, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Mr. Millicent, did you read the plea agreement?
Yes, I did.
Do you understand it?
I understand that from here on, I'll be a convicted felon, yes.
Yes, sir.
And,
And you also understand that you're waiving your right to a trial by jury?
yes,
Mr. Millicent, did you discuss the plea agreement with your attorney?
yes,
Did he answer all of your questions?
yes,
Are you satisfied with his representation?
yes, I am.
Did you sign the plea agreement?
I did.
Mr. Millicent, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. You'll need to pay the court costs, $150 public defender's fee. How long will it take you to pay? A little less than $800.
If my attorney indicated that I'd be able to request up to a year
Yes,
to
sir.
pay. If that's possible, I am on a fixed income.
Okay. If you fail to pay the financial amounts within a year, then they'll go to a civil lien or judgment.
Okay.
Thank you, sir.
Thank you.
Thanks. Yep. Your Honor, if we could recall Joseph LaCrosse.
Mr. LaCrosse.
Mr. LaCrosse was not here earlier. He was running a little bit late. The court has issued a capias. Given his appearance, we would ask the court to withdraw that.
The capias is withdrawn.
And, Your Honor, we do have across two cases. In case 23 CF 2275, we have receipt of a 4-count information. In 23 CF 2276, it's a 1-count information. In both cases, we will waive the formal reading, enter a not guilty plea, and ask that these remain set on the January 8th docket.
Okay. Mr. LaCrosse, make sure you're on time next time, okay?
Yeah, I was just, yes, sir.
Okay. And I'll see you back here January 8th at 9 o'clock.
Yes, sir.
Thank you.
Thank you.
And the last I have on the morning, Your Honor, or the afternoon arraignment docket, court security pointed out with Mr. Aurelian, Mr. Aurelian posted a cash bond, and on his cash bond, it gives his arraignment date as November 11th. It does not give it as today. And as a matter of fact, mail was returned for Mr. Aurelian. So given that, I would ask the court to withdraw the capias, but put Mr. Aurelian's case back on for the 22nd, for next Wednesday.
I do withdraw the capias for Mr. Aurelian, put it down for a status conference on November 22nd.
And I'll see if we can get in touch with him this week.
Good.
Thank
You want me to just reset the felony plea day for next?
That'd be fine. Yes, ma'am. Arraignment? Yes, ma'am. Anyone else for 1:30?
Yeah, yes, I have.
Okay,
minutes.
but why don't we talk about that? If you have folks here, let's do that. If
Yes.
not, we can wait on the ones that aren't here.
Judge, I have Megan Scholes, who's present.
Ms. Scholes?
And approaching, Your Honor.
Good. Hello, Ms. Scholes.
Hello.
Yes, sir.
Information has been filed. We'll be entering not guilty, waive formal reading. Give my contact information to my client,
Okay.
Your Honor.
Ms. Scholes, I'll see you on January 8th at 9 o'clock. Stay in touch with Mr. Koch.
Yes, sir. Thank you.
Thank you, ma'am.
Thank you, Judge.
Mr. Koch, I've got her availability.
Okay, thank you.
Okay. Anyone else for 1:30? Okay. We'll take a 10-minute recess, and then we'll come back and finish up the afternoon. Thank you.
All right, please.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
What can I help you with?
I think I was bit by a vampire.
This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his client.
Quick.
Okay.
May I call Antral James? Mr. James is present in the courtroom. He missed pretrial, and a capias was issued. Got in contact right away, and we got him here today. We're asking the court to withdraw the capias.
Mr. James, the capias is withdrawn.
It's case number 23 CF 1916.
Okay. So what are you doing with that case?
Judge, we'd like this to be set on the 1/8 pretrial docket. We did not cancel the depositions we already have scheduled for December 15th, so we should be in a position to move forward by the time we get to pretrial on 1/8.
Okay. See you on January 8th at 9 o'clock.
Yes, sir.
Thank you, sir.
Okay. Thank you, Judge.
Mr. Snow, you look perplexed. Okay? Thank you.
Your Honor, Mr. Lobello was out on bond in 22 CF 3007. He got arrested on a juvenile battery case, 23 CJ 704. We have since resolved that case, and so I filed a motion to reinstate the bond. I believe the state's willing to stipulate. We've got special circumstances in this case. We've been hunting for witnesses, and we got one of them served, and they didn't show up. Didn't get another one. We couldn't find the other one, but I think they're going to stipulate.
Yes, sir. To the state?
That's correct, Your Honor. The state is going to stipulate for the reasons that Mr. Knopp stated. Also, this case is set for trial, so the state's position is that, you know, either this case is going to get resolved. We don't expect Mr. Lobello to not be here. There is a very short amount of time between now and when the trial is set for. So between that time, we will get this case either resolved or we'll be ready for trial. And in that regard, Mr. Lobello can be out.
Okay, so, Mr. Lobello, your bond is reinstated. Am I going to see Mr. Lobello on January 8th?
No, Your Honor, it's the 20th docket day.
Got it, okay. I'll see you on Monday then, on the 20th, okay? Make sure you're here, it's at 9 o'clock. Okay.
Thank you.
Thank you, sir.
Call your dad and let him know, okay? You bet.
Miles?
Yes, please. Judge, Mr. Miles' case, we have been hunting for witnesses and had come up empty on trying to serve one of them. We got another address and then another address, but ultimately had not been able to find her. I believe the state, from what they've indicated, they've sent me an updated discovery, Second Amendment discovery. They have found the alleged victim now. And so for that reason, number one is that I need to take the child's deposition. That's a big issue. So we're not ready for this go around to try the case. But today we had filed a motion to consider ask the court to consider modifying the bond. He's been in jail now for quite some time, for well over a year, and it's a $300,000 bond. And we're asking the court to reduce the bond so that he might be able to post a bond to get out, seeing how it's just taken a lot longer than it should have.
Okay, to the state?
Judge, we believe the bonds are appropriate as set. We oppose lowering them in this case. He's currently charged with lewd lascivious molestation of a victim under 12, which, as the court's aware, does carry a 25-year minimum mandatory prison sentence. This particular abuse happened over a period of years with a live victim, aged 1 to 5. There were numerous documented incidences with OCSO and DCF that involved the defendant and this child. The victim actually has an injunction against the defendant from Judge Polson, and also one that prevents contact between the defendant and the victim's half-brother as well. Notably, the defendant's own son, who is the victim's father, who was adopted by the defendant at 16, testified in front of Judge Polson that he was also sexually abused by the defendant for years before his own child was born. And when he witnessed some concerning incidences with his son and the defendant, he filed for the injunction. That injunction was granted, and the child victim in this case did come to the CAC about 2 weeks ago. We had some discussions with him and can be ready to proceed, but as Mr. Knope stated, they will need to depose him first. The child obviously does not want contact with the defendant, and his guardian does not want him out of custody. Importantly, the unavailable witness that was mentioned by Mr. Knope previously is not the child victim. It's the victim's biological mother who does not have custody of him. the defendant was at one time financially supporting her and did allow contact between the victim in the case and the defendant until DCF got involved. So we believe the bonds are appropriate as set. We'll be ready to proceed after depositions, and we would ask the court to leave the bonds as they are and request intensive sex offense level, weekly in-person pretrial reporting, GPS, and no contact with minors.
Was that on the original bond or no?
There was sex offense level, but not the intensive weekly importing pretrial.
Okay, thank you. Mr. Nopes?
Judge, again, you know, it's one count of lewd lascivious behavior, but the bigger part to me is that it's just, he's had to sit in jail and wait, and now, I mean, like at the 9th hour, I mean, they find the alleged victim.
Mr. Miles, and I had a similar case earlier this morning, and someone moved to modify the bond based on not being able to get depositions with the state for months. Some law enforcement officers didn't show up in that case. When I look at it, and I did my homework, I read through the motion and also the arrest report. When I look at that, it's almost that the defense, your attorney, and he's an advocate for you, and I don't blame him a bit for doing it. But from the court's perspective, the defense is almost saying, Judge, you should sanction the state and change the bond because the state is delaying the case. I'm not aware of any authority that says the court has to do that, or even any guidelines that says how I would determine they've delayed them for 3 months, so I should knock off this amount of money off a bond. Also, you know, the state represents the state of Florida, the citizens of Florida, not just the attorneys themselves. Based upon the allegations against you, respectfully, your motion to modify bond is denied. There are other mechanisms that Mr. Nopes can use, motions, orders to show cause, to make things happen faster if he doesn't like the way that they're happening. And I'll certainly rule on any motions that are brought before me, but as far as the motion to modify bond, respectfully, it's denied. So will I see Mr. Miles on the 1st?
Judge, I think he's actually on the docket.
He's on for Monday.
Docket day. What do y'all want to do about that?
Judge, I think it has to, I mean, it's
You
going
need
to
to
be
depose.
continued. So, I mean, because
Okay.
I've got to take this deposition.
So do you want to continue it until January 9th, or do you
Judge,
want to,
I think that would
I mean,
be,
January 8th, I'm sorry.
January 8th is fine.
Okay. So, Mr. Miles, I'll see you back here on January 8th. Thank you, sir.
Judge, I believe that's all I've got.
Thank you, Mr. Nopes.
Have a great day.
You too.
Yeah, that's, you're on. That's 100%. Yeah, that guy.
Yes, ma'am.
On the corner of your desk.
Oh, okay.
The other picture of it is missing.
Yes, ma'am.
She has it, and she's the e-file as well.
Okay, thank you. So 22 CF 1999, 23 CF 1585, 22 CF, that's it, I think. Okay? Yes, sir. Why do I have Mr. Stansberry back?
He's got a food form that was given to him.
Okay.
He said he just has a couple of quick questions.
Okay. Yes, sir, Mr. Stansberry.
Actually, I only have just one question, Your Honor. I'm going to agree to the plea agreement, but it states credit for time served on count 3. I was asking for credit for time served on all charges pertaining to the VOP.
To the state?
That would be count 1 and 2 for for all the VOP.
Okay,
I
so
was just,
that count 1 is a new law application we're talking about.
the count 1, the larceny petty theft was part of the violation, sir. The third count, the subsequent 3, the only new
See the possession of drug paraphernalia?
Yes, sir.
You're not going to prison for that charge.
I know, that's a
You're just
misdemeanor.
Time served, that's what that's saying.
Okay, but you're not giving me no jail credit for all the time I've
You're
served?
entitled to time that you've served on these charges already. You are entitled to.
I know, I was just hoping to have it in writing. DOC is kind of funny about stuff not being in writing.
Okay, so, Mr. Snow, you don't object to Mr. Stansberry receiving credit for all time served
That's my
on?
only question. I agree to everything else.
Yes, that's correct.
Okay.
He's entitled to any jail time he's already served on these charges. Yes,
Okay.
Yes.
Yes, ma'am.
Do we need to give him a copy of this since he is his own attorney?
Yes, ma'am.
And that was my only other question. She just answered it.
What are those case numbers
So, yeah,
again?
I mean, if you could just write that in, or
22
just write that in,
CF
credit for all jail credit.
1999.
I mean,
And 23 CF
Yes, sir.
1585.
but like I said,
BOPs.
Ma'am?
They are both BOPs.
I think the 23,
okay.
Mr. Snell,
am I going to get a copy
23,
of this?
Mr. Snell said is a new
Am I going
charge.
to get a copy of this?
There's not. It's two VOPs. I'm sorry.
Okay, good, thank you.
One more quick question, Your
Yes,
Honor.
sir.
Will I be getting a copy of this confinement papers, or do I need to write the clerk of court requested a copy?
How can he receive a copy, pro se?
You would need to send a request to the clerk.
Okay, request to the clerk, yes, sir.
Yes, okay, okay, yes, Your Honor.
Can I ask
Yes, I did,
probation?
Your Honor. Yes, I did, sir.
Sure.
Yes, I did.
Was this e-file to be
Probation.
worked up as a warrant? This isn't going to be worked up as a warrant, correct?
No, it's not more than just advertising.
I just wanted to make sure, because it hasn't been reopened in our
It's right
system,
here.
because we don't
This
have
page right.
that document yet, it hasn't been processed yet. So I just want to make sure after he gets sentenced, it's not going to be processed as a warrant, and then that's going to cause issues, okay?
That's the violation. This is this sheet right here.
Okay.
So I'm going to hand it to the clerk.
Yes, sir. Yes, sir.
Oh, okay, I will, thank you. Thank you, sir. Okay, thank you. So, Mr. Stansberry?
Yes, Your
If
Honor.
you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Stansberry, are you currently under the influence of any drugs, alcohol, or medication?
No, Your Honor.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No, sir.
How far did you go in school?
I have a associate's degree, 18 months college. Yes,
Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, Your Honor.
Did you discuss it with the state?
Yes, sir.
You're representing yourself. Any questions about the sentencing recommendation, the plea agreement?
No, sir. None whatsoever.
You understand that you're waiving your right to an evidentiary hearing, violation of probation hearing, where the state would have to prove the violation against you.
Right.
And you understand that you'll be sentenced to 18 months in prison, correct?
Yes, sir.
Okay. Mr. Stansberry, and did you sign the plea agreement?
Yes, sir, I did.
Mr. Stansberry, I do accept your plea. You're adjudicated guilty. You're sentenced to 18 months with the Department of Corrections. And that's on counts. That's in 22 CF 1999, counts 1 and 2, concurrent, running at the same time with count 1 on 23 CF 1585. You need to pay the $250 cost of defense, $200 cost of prosecution. All court costs, fees, and other restitution will be sent to collection 120 days after your release from the department if you fail to pay those by then. Credit for all time served on all of the counts. All the sentences are to run concurrently. It's time served on count 3 of 22 CF 1999. Yes, sir.
There's one thing I left off.
Okay.
Was ordered to pay restitution on
Under this, it says that will be sent, oh, okay. Yes, sir. It'll be sent to a civil lien versus collections 120 days after you get out if you fail to pay it.
Yes, Your Honor.
Probation.
Revoke and term is probation.
Supervision is revoked and terminated, and this is a downward departure, and that's why it's less than the score sheet. Mr. Stansberry, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, Your Honor.
Thank you, Mr. Stansberry. Yes, sir.
I do want to say one thing about our earlier discussion. I just wanted to know that your attorney spent close to 4 hours with me yesterday working your case. It was
I understand.
Very hard for you.
I understand. I respect that and I appreciate that, but like I said, I just wanted to get this over and behind me.
And I wanted the court to understand that.
Oh, yes. I
Understand.
wanted Mr. Collins to understand this is nothing personal. This is just, I just wanted to get this over with and done.
Thank you, Mr. Stansberry.
Thank you.
Okay.
I believe we're doing Jeremy Merkwa next.
Mr. Herkwa. So this is Mr. Merkwa's case, 22 CF 251.
Yes, Your Honor, Mr. Merkwa is present. Before we start, I just wanted to clear up an issue on the sentencing letter. In my sentencing letter, I had written that Mr. Merkwa, that sex offender probation realistically should not be transferred or could not be transferred. I know the state in their letter said actually it could. I actually had multiple discussions with different probation officers. It seems like there's a disagreement in the office. I have no problem if the court wants to put Mr. Merkwa on sex offender probation. As I only even brought it up, as a matter of fact, I didn't even know he could avoid sex offender probation until after talking to probation. I actually read the statute, and it still seems weird to me that you don't have to be placed on it, but I did want the court to be aware his residency was the only reason that was ever an issue. And so I have zero problem with the court placing him on sex offender probation. So I just wanted to bring that up to the court. So, because that, as soon as I saw her letter, I was like, you got to be kidding me. Like, I just talked to probation.
Yes,
so.
sir. Thank you.
But Mr. Merkwa is present, Your Honor. We are going to call a couple of witnesses in this case. If we can start with Dr. Randy McDonald.
Please, Dr. McDonald.
Do you swear or affirm that the testimony you're about to give to be the truth, the whole truth, and nothing but the truth? Thank you.
And prior to her testifying, Your Honor, I talked with Ms. Barrickman. I believe the state would stipulate that Dr. McDonald can offer opinion testimony.
That's correct.
Doctor, you evaluated Mr. Merkwa a couple of times, correct?
Yes, sir.
One of the evaluations you did was a risk assessment, right?
Yes, that was a component.
Okay. Now, kind of chronologically going through your report, the first thing I noticed is that your report references an assessment of nonverbal intelligence called the CTONI. What does that stand for?
That is the comprehensive test of nonverbal intelligence.
And what is that? What's that looking for?
So basically, it provides a measure of intelligence through nonverbal measures. So if someone presents with low verbal abilities, or maybe they speak a second language, we will rely on these nonverbal measures to get an estimate to the best we can of intellectual ability.
Like, what kind of questions are there on the test?
So I actually have not given this specific one. So I looked it up on the company website that sells it, and they specify that it includes measures of analogical reasoning, categorical classification, and sequential reasoning. So the measures of analogical reasoning, that's going to be very similar to one that's given on the IQ test that I use. It's called matrix reasoning, where basically they're given an increasingly complex type figure. There's a piece missing. They have to choose the missing part from one of the 5 choices. So it's going to be something like that.
Oh, okay. And what was Mr. Merkwa's results on that particular assessment?
So the documents I had noted that he scored in the low average range, so mid-80s.
Okay, and what does that, how does that play into an evaluation? I don't really understand kind of the purpose of that.
So the assessments that were being done when he was a child were done by the school. So he had come to the attention of his teachers and administration that this was a child that was struggling in school. He had repeated kindergarten, and then in first grade they started doing some more formal assessments. So it's really just a kind of a quick and dirty way to get there and assess intelligence, nonverbal intelligence, and to kind of start that process of introducing interventions within the school setting.
Okay. Your report also references something called the DAB-3. What is that?
So that is a diagnostic achievement battery, and again, this is not one that I use. Most of the measures that are referenced in those early evaluations are most commonly used in the school system by school psychologists. And this is Alabama that he was being tested in, and so their school districts may have different instruments that they rely on compared to what we use here in Florida. But it's again, I researched it, looked into what it was, and it's going to be a measure of academic achievement consistent with some of the other measures that we might rely on more heavily, but it's going to look at reading, writing, and math abilities. And again, it's a way for them to assess objectively how he's comparing to other students his age on those specific areas, and to determine where he might benefit from interventions within the academic setting.
What were his results on that particular DAB assessment?
So they had noted specific difficulties within mathematics, listening, and speaking. Again, I'm not intimately familiar with that measure, so I couldn't really tell you exactly how that's assessed, what the subtests are like. But those were the general areas that we identified them as having deficits.
Now, as part of your evaluation process, did you review Mr. Merkwa's school records?
I did, yes.
Okay. Was he in special education classes in school?
He was. In first grade, it looks like they started with an individual education plan. They started getting him additional assistance throughout the rest of the time in school.
Now, I had heard earlier you referenced that he had repeated kindergarten. How do you know how common that is?
I couldn't give you a statistic on that. Just from my own, experience clinically. I've done evaluations now for 20 years, giving these tests and all of that. It's not something you see a whole lot. Typically, it's going to be from children that are demonstrating social skills deficits, or maybe they're just not getting the very basic things like colors and alphabet as kids that age should be doing. But it's not common that you see someone repeat kindergarten.
Okay. Now, were the problems, so you reviewed his IEPs, right, the individualized education plans?
Yes.
Were the problems that you saw noted in those IEPs some of the same issues you were seeing at the time you were evaluating Mr. Merkwa?
Yeah, pretty consistently they noted academic deficits, and at that time it was really across all subjects. And again, they used different measures of intelligence, but there was this pattern of sort of lower verbal abilities compared to nonverbal abilities. So that pattern was repeated into the more recent testing that I did. Looking at his grades and things like that, his grades were fairly poor, well into high school. Lots of the teachers said, behaviorally he's not a problem, he's a good kid, but he wasn't doing his work, wasn't really applying himself. If he didn't understand something, he wouldn't seek help. So you see some of that kind of early signs of that social anxiety where he's not reaching out to get assistance and all of that. He's just sort of doing his own thing and withdrawing.
Where do you think Mr. Merkwa's current, as an adult in his 20s, where do you think his current reading and writing abilities stand from a grade perspective? Like, is he up to speed with everyone else, or is he still?
No, he's below average. So I administer the wide range achievement test, and it's just a real kind of a quick measure. It looks at spelling, it looks at word reading and recognition, sentence comprehension, and then get 2 pages of math that get increasingly difficult. So it's just, again, kind of a quick and dirty assessment of where they are. So with his reading and spelling, he was at, I think it was 7th grade for spelling and 8th grade for reading or something of that nature. So he's, low average. He did better than I expected, but if I could give him a more involved measure of academic achievement, like Johnson, where it looks at fluency and kind of application of skills to more complex problems, then we may have seen greater deficits across the abilities.
Okay. Now, when you were evaluating Mr. Merkwood and giving him these types of assessments and for lack of a better word, tests, did you get the impression he was trying to fake anything, or did you think he was putting forth his best effort?
I felt he put forth his best effort. I mean, I will certainly say if I think someone was not, he was very attentive. He didn't take any breaks, didn't ask for breaks. I offered them, they weren't taken. He was very engaged, didn't have problems understanding the standardized directions or anything like that. So I didn't have any concerns about his effort in the testing.
Now, part of your evaluation, you gave Mr. Merkwa an IQ test, is that correct?
I did.
That's the Wechsler Adult Intelligence Scale?
Yes.
Okay. Now, on that particular assessment, how did Mr. Merkwa do on his verbal comprehension?
So the verbal comprehension index was certainly his weakest area. He obtained a standardized index score of 68, which falls within that extremely low or impaired range.
Okay, and his percentile rank, according to your evaluation, was 2? 2,
yes.
Does that mean that he scores better than 2% of the population?
Yes.
Okay, so 98% of people will score a better score than he would?
Yes.
Okay. How important is verbal comprehension, like in terms of an IQ assessment?
It's really important. I mean, I would say all of it's important when we're looking at IQ, but certainly when we're looking at verbal comprehension and verbal intellectual ability in more general terms, that's going to be something that can cause a lot of, functional struggles in the real world. It's going to affect communication, both giving and receiving communication. It can affect learning. A lot of how we learn is presented verbally. We read things, we listen to things, we take that information and use it. Using verbal information and abilities to solve new problems is impacted when someone's verbal and when verbal comprehension is low. So it just affects the person in many ways.
Okay. Now, what was Mr. Merkwa's full-scale IQ?
So his full-scale IQ was 76, so that falls within that borderline range.
Have they've moved away from like a bright line number, right? It's no longer considered like just automatically if you're above a number, you're not impaired, I guess. Is that fair to say?
I would say the field of psychology's never really had a bright line.
Okay.
We always have gray areas and exceptions. In terms of diagnosing intellectual impairment, they really have kind of reduced the numerical, have taken out the numerical parameters of that, and are encouraging us to rely very heavily on assessments of functional adaptive behaviors. So it's looking at social and practical and communication skills. But I think most of us who have been in these fields and doing these assessments are going to still look at IQ, and we're expecting to see a certain level of impairment. And certainly with the IQ test, they give us qualitative descriptors, and so we're going to be looking at qualitatively how they compare to that non sample, and so you're going to see impaired and extremely low and those kind of things. So in terms of the borderline intellectual functioning, that diagnostic criteria within our diagnostic and statistical manual has increasingly been diminished. I mean, it's very vague at this point. It used to be that anyone who had an IQ between 70 and 84 could qualify for that diagnosis. We're not taking out those numerical parameters, and they just kind of leave it up to us, the clinician, to decide if someone meets that criteria. So I certainly, when I have an IQ test and someone's full scale is coming out at 76 or 73 or whatever it may be, I'm going to be looking at that as a potential diagnosis. And typically we have some accompanying impairments or weaknesses and dysfunctional adaptive behaviors as well. So it holds the value in that it's just sort of pointing out that this is someone who not fully impaired, but also not functioning at the rate that we might expect someone of that age.
Now, your report states, quote, "The verbal comprehension index suggests impairment on that unitary measure of verbal concept formation and reasoning abilities," end quote. Can you explain that in English?
So our IQ tests are made up of lots of different subtests, and then we take them and we clump them together to give you these composite scores. And so the verbal comprehension index is comprised of a vocabulary subtest, similarities, and information. And then there's alternate subtests you can use as well. But basically it's just saying that when I gave him these 3 measures of verbal intellectual ability, put them all together, it's showing that he's got impairments collectively, and then you break them down individually within the subtest scores, and you can see he's below average within those as well.
Would it be fair to say, and I don't know if this is correct, but would it be fair to say that he's below average pretty much consistently across the board when it comes to verbal?
Yes.
Okay. Now, you note a 24-point difference between that score and something called PRI. What is the PRI?
So the PRI is the perceptual reasoning index. So if we want to really simplify it or even kind of go back to previous versions of this particular IQ test, that's going to be your nonverbal intellectual abilities. And so those subtests look a lot like puzzles. I talked about one earlier where you're given an illustration or a figure, and there's a piece missing, and you have to select the missing part from the 5 choices below. So that's an example of one of the subtests we would give, putting blocks together to make them look like a certain pattern. So those are very kind of hands-on kinesthetic type skills that someone would have. And with him, that's really his area of strength. And so he scores just right in that, right within the average range. And again, that's pretty consistent with what they saw when he was growing up in terms of testing that was done then. So that huge difference that we have is pretty abnormal within the normative group on this particular measure. You only see that in about 3.7 to about 4% of the normative group would have that big of a difference. So it's really indicative of someone who's got a pretty profound weakness within those abilities, specifically the verbal abilities.
Okay. What is the Hare psychopathy checklist?
So the Hare psychopathy checklist is an instrument that we use that looks at 20 different traits or behavior histories or components of what we identify as psychopathy. So I use it in the risk assessment because people that score high on that measure are going to be typically more likely to reoffend criminally in the future, whether it's a sexual offense or non-sexual offense. And so these are the people that are also going to have some challenges within the therapeutic setting and all that kind of stuff. So it's a measure that I think holds some value with the risk assessments to help identify those specific challenges.
And what was Mr. Merkwa's score on that?
He obtained a score of 0 on that.
Psychologically speaking, or I guess technically speaking, what is psychopathy?
So psychopathy, the way I look at it, is just a really severe form of antisocial personality disorder. So we would say that most people that we consider to have high psychopathic traits, or if you were going to call them a psychopath, that's not really what we do anymore, but someone who has high psychopathic traits is most certainly going to meet diagnostic criteria for antisocial personality disorder. But not everybody with antisocial personality disorder will have high psychopathic traits. So it's just really sort of this person that has these antisocial traits kind of to the nth degree. They take it to the next level, and it really encompasses everything they do in all their interactions. And have a lot of trouble or cause a lot of trouble for people.
Okay. I know that word gets thrown around a lot.
Yes,
I'm sure
it does.
it drives you guys up a wall. So I just was curious what exactly that was. Now, how did Mr. Merkwa do on his polygraph exam?
He did fine. The questions are listed out there in the report. He responded no to each question that was posed. The polygraph examiner concluded that he was truthful in his response to those questions, so there was no concerns raised on that.
What is the stable 2007 assessment? What is that?
So that is a measure that looks at dynamic risk factors or what are called criminogenic needs a person might have. So it looks at more of the kind of personal traits a person might have that increases the risk for reoffending in a sexual way. And now there's some overlap between the things that are assessed here and those that look at just general reoffending behavior. But it's going to look at things like social troubles, impulsivity. It's going to look at sexual deviance, those kind of things. So it just looks at all different kinds of things that can increase someone's risk for reoffending if they're present, but it also provides us insight on where we can intervene. So these are the points of intervention that we can identify and build treatment plans with the intent of mitigating that risk and reducing reoffending in the future.
And I should back up, just I don't want to lose the court. All these assessments I'm about to ask you, I believe they all take place first risk assessment, is that right? The stable 2007, the static 99R, these are risk assessment type of evaluations?
Yes.
Okay. What was Mr. Merkel's score on that stable 2007 assessment?
So on the stable, I rated him as a 3 out of a possible 24. So that falls within the low range.
And so what does that mean? Like if he's 3 out of 24, does that mean he doesn't need services or he doesn't, what exactly does that mean?
So on the areas where I rated him, these were areas that I could see where he could probably benefit from some interventions. These weren't significant impairments or problems that he has. These are rated on a 0, 1, or 2 scale. If something's rated as a 2, it's a pretty serious problem. It certainly needs intervention. With him, he just had 3 things that kind of popped out to me throughout the evaluation process. Capacity for relationship stability was 1. This is someone that is going to get a 1 just because he's never been married. That's part of it. During the course of the time I met with him, he had been involved in a long-term relationship, maybe not a typical romantic relationship that most of us would describe, but he had a committed relationship. So for him, it wasn't that he fully lacked capacity, it was more there hasn't really been, I guess, an opportunity to demonstrate that capacity. So I just gave him a 1 versus a 2 on that. General social rejection, this was something that came through in talking with him just in terms of being bullied as a child and having trouble at work, kind of not feeling supported by coworkers. He has some social anxiety. So these are things, just general social rejection is kind of present in his life. Not entirely, he's got supportive family, but again, it's just something that I think causes him some struggles in life. And then finally, poor problem solving skills. This is one that, I'll ask him, what kind of problems you had in life, or what's caused your problems, and he said, I don't have any problems. Well, there's a big legal problem here, so that was one thing. One of the things that came through looking at his school records and stuff was this was someone who lacks assertiveness, and that was something that his mother even said when we spoke to her. And he wasn't one, even as a kid, that would reach out and ask for help. This is someone who's got some problem-solving challenges in terms of not being able to really identify when there's troubles, and then also not really knowing how to deal with them when they are identified. So again, these are just areas of mild difficulty, but I think they were relevant and certainly points of potential intervention.
Are those the types of things you were just describing, the lack of assertiveness, is that, I guess, compounded by the nonverbal issues that he has? Is that?
I think so, and I think we haven't talked about it yet, but social anxiety was another thing that came out through the testing and talking with him and looking at the records, that you got this, I guess, maybe sort of trifecta of things compounding together, where it may be hard to find the words or to express feelings or needs because of the low verbal abilities, and then also not feeling like other people would even listen or even respond positively if he did share the need. And then also just the social anxiety, the fear of being judged and just kind of wanting to pull away and hide from others.
So what was the overall result of the risk assessment? What level of future risk do you think Mr. Merkel poses?
So based on the instruments that I use, he did fall within that average range of potential for reoffending sexually. So the static 99R came back with a score of 4, and that was really what elevated the risk level. So when you combine that with the stable 2007 score of 3, that put him in that average range.
Okay. And briefly, what is the difference between a static risk factor and a dynamic risk factor?
So the static risk factor is really things that we can't change. So the form, the table of it, basically it's going to look at someone's age. So anyone that is 35 or below at the time of the release from the they're going to get a 1. So anybody below 35 is going to have a 1. He hasn't been married before, hasn't been in a long-term live-in relationship. It has to be 2 years you've lived with a lover to count as a marriage. So he hasn't had that, so he's going to get a 1 for there. So right there he's got a 2, and that already puts him in the average range. And then the crime-specific things that are rated on the static would be that the identified victim was a stranger, so this was someone you knew less than 24 hours, and also someone that was unrelated to him, so that adds the other 2 points. So the static is really just, again, demographic characteristics, and then also crime-specific characteristics. So there's not really anything we can do about it. It just is what it is. And it provides us with an opportunity to kind of quickly compare the person we're evaluating to a group of people known to reoffend. So we know that younger men who've never been married, who have criminal histories, who engage in these types of crimes are going to be more likely to reoffend than someone who's not.
Now, did you formally diagnose Mr. Merkel with social anxiety disorder?
I did, yes.
Okay. Do you think that Mr. Merkel has intellectual deficits combined with those social anxiety issues? Do you think that has anything to do with his conduct in this particular situation?
So I've done a few of these evaluations very similar to this case, where I have someone who has these charges and who presents with intellectual impairments. And I would say more generally, I've had a lot of cases where I have folks that have these kinds of charges or other sexual offenses who have neurodevelopmental delays, they're just socially awkward, and they just have a lot of difficulties. So I think when you combine social difficulties and the lower intellectual or even just lower problem-solving skills, I think that it makes someone engage in these behaviors without really thinking about the true potential consequences of it. And I think that, when talking to people about why they did things, loneliness is a big factor. It's never like, I'm going to go out and offend against someone. It's sort of they have this loneliness that they need to address. Or sometimes it is just for sexual gratification. Not the intent to offend against someone, but just I have these needs I have to get met. And then I think you added this component of the internet where it's very easy to get on there. There's no social judgment. There's no no one making you feel bad about it. And so I think it's easy to get caught up in these situations. So yes, I think the combination of the lower intellectual abilities, the problem-solving deficits, weaknesses, and the social struggles certainly put someone in a position where they might do something like this.
Ultimately, you gave the opinion that you don't believe that Mr. Merkel needs sex offender-specific treatment. Why did you make that statement? Why do you believe that?
It's not to make my job difficult. What we're seeing in the research coming out now is that there's been a tendency to sort of over-prescribe interventions. And so the recommendations that we're getting now from research is that if someone is below average for reoffending behaviors, we shouldn't recommend it at all. It really should just be, maybe community supervision and they kind of get on with their life. And he is in that average range, and so certainly I would be qualified in saying, yes, he should have sex offender-specific treatment. But I think in his case, the difficulties that he has, the needed areas of intervention, aren't really going to be addressed by sex offender-specific treatment. They will in some regard, but then there's going to be all this other stuff. That's the focus of interventions. And I don't know that that would be super helpful for him. For him, I think it's really going to boil down to addressing the social anxiety, helping him develop some productive assertiveness, helping improve communications, talking about building relationships, romantic and otherwise. And that can be done partially, again, through sex offender probation, but I don't know that it should be a specific requirement for this specific case. I also understand the court has to make recommendations to address the issues at hand. So I don't think it would be harmful, but I try to be conscious of the limitation in resources and a defendant's limited ability to access them. And there's a bit of a challenge in this case, particularly because he lives out of state, and I couldn't find any programs near him to make a referral to or to find out what would be appropriate for. So the only program I could recommend is in Pensacola, and that's going to pose a bit of a challenge for him, I believe. So I think that the challenges he has, the needed points of intervention could be addressed through a good, typical therapy relationship.
And one of the reasons why he's at an average risk to reoffend is because of some of the static reasons that he can't control, correct?
Absolutely, yes.
Okay.
And the therapeutic interventions are going to be much more focused on the dynamic risk factors, the things that are identified through that stable 2007 measure.
Now, regardless of what the court sentences Mr. Merkwood to, are a lot of the issues that he has right now, are they going to kind of follow him the rest of his life, be with him the rest of his life?
I would opine that they would. Certainly, I think that therapeutic interventions can help manage some of the social anxiety. You know, we put a name on it, now what do we do with it? So I think someone's getting there and help him understand what it is and how it affects him and help him come up with coping skills. But that condition, I don't know, is going to just completely resolve itself. It's been his whole life, and it's probably going to be a struggle as he moves forward. And certainly with the cognitive weaknesses that we've identified, those are pretty fixed conditions, and that's going to be what it is.
I don't think I have any other questions. Thank you.
To the state?
Just a few. Good afternoon, Dr. McDonald. Under reason for referral, it mentions the psychosexual evaluation and the risk assessment. Is that correct on your first page?
Yes, ma'am.
Okay. And at some point during your interviews with the defendant, isn't it true that he denied engaging in the behaviors that led to these charges entirely?
He did. He consistently denied it.
Okay. He actually blamed someone else for the crime. Is that correct?
He did.
He said he found his phone by the entrance to his neighborhood upon arrival home from Mississippi, opining someone had dropped it by his house before he left. And while he was away, he later located it when he came home. Does that sound accurate?
He opined someone dropped it by the entrance to his neighborhood, but yes, that's
okay. And he denied using the apps that were part of his crime. Is that also correct?
Yes.
And you had an opportunity to speak with his mother as well?
Yes.
And when you spoke with her, was she able to corroborate his story about losing his phone and randomly finding it in his neighborhood?
No. This was a point that I tried to address with both of them in that process because I immediately picked up that there were some contradictions, and when I asked her about it, she sort of recanted and said, well, I don't remember, I'm not sure. So there were some inconsistencies in that report.
Okay. So ultimately, on the static 99R and the stable 2007 combined, your opinion is that he's of average risk to reoffend, is that correct?
Yes, ma'am.
Okay. No, I don't think I have anything else further. Thank you.
Mr. Vines, and you redirect.
Just briefly, is it totally unheard of for somebody with his cognitive issues and his social anxiety issues to have trouble admitting certain things that seem obvious to other people?
I would say yes, and particularly with Mr. Merkwood, he was obviously very comfortable talking about the nature of the offense and his sexual history and all those kind of things. And it was definitely a struggle. And we had the challenge of having to do this in a truncated manner because of the difficulties he had getting here to do the evaluation. It's a lot of things that I do. I don't always add in the IQ and achievement testing. That was something I just kind of did because I thought it was needed. So I didn't have the time that I would normally be afforded to really build a rapport and kind of help someone get comfortable talking with me. And I think being a female makes it difficult for a lot of the defendants I see. So sometimes I see them 2 or 3 times before I can really have a good conversation with them about things. So I think there were a few factors there that interfered with maybe getting all the information that's available.
Even if somebody is just a normal, and I hate to say normal, but doesn't have Mr. Merkwa's intellectual issues, do you still have the issues having people acknowledge some of the things that they've done in evaluations?
All the time.
Okay. I have no further questions.
Thank you. Dr. McDonald be released.
Yes, sir.
Yes, Judge.
Thank you so much, Dr. McDonald. Thanks for being here so long this afternoon. Your next witness.
Just briefly, I'm going to call Michael Burns.
Mr. Burns, please come to the stand. Okay.
Watch your step right over this way. So stand right here, face that clerk, and raise your right hand.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
All right, you can have a seat. You have to be present with that microphone. You can move it if you need to.
And, sir, can you go ahead and tell us your full name?
My name is Michael Andrew Burns.
And how do you know Mr. Merkwa?
He lives in the same trailer park that I live in. I've been knowing him for about 8 to 10 years, and he's one of my best friends.
How often do you guys spend time with each other?
During a week, probably 3 or 4 days. Out of a week, 7 days.
Has Mr. Merkwa ever done anything in your presence that's given you concern or caused you to kind of
Never. And he's never even raised his voice to even argue at me. I had never seen the violent side to him, and I don't know him as a pedophile. I know him as a good person on my end. I never seen him talk about women or young women or gentlemen in any provocative way. I haven't.
Does he have a lot of friends? Do you see him with a lot of other people?
Yeah. He's got a big family, so I know his family too. He's around a lot of people.
Okay.
He talks to people.
Spend a lot of time with his family?
Yes, he does.
Does he spend more time with his family than he does other people that he's not related to?
Probably. Yeah.
I have no further questions. Well, let me ask you this. Is there anything else that you want Judge Brown to know about Mr. Merkwa before the judge decides an appropriate sentence here?
I hope he'll go lenient on him and at least give him a chance. And to me, what I've seen of him, I'm just a poor man, but he's a good guy, and he tried to do step by step with y'all to go through the right process, whatever happened, and I just don't know him as that person or as a pedophile, and I just know him as a good guy, and I wish I'd go lenient on him and give him another chance.
I don't have any other questions.
To the state.
I don't have any questions.
Thank you so much, Mr. Burns. Thanks for being here.
And the last witness I have will be Mr. Merkwa, Your Honor.
Okay. Mr. Merkwa, please come to the stand.
You'll face the clerk and raise your right hand.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Thank you, sir. If you'll please be seated.
You can leave that microphone.
Good. Thank you.
Mr. Merkwa, what do you do for a living?
As of right now, I don't do anything.
Okay,
I'm not working or anything, but I recently just lost my recent job that I had back in July.
Was that at Mullinax?
Yes.
Car dealership?
Yes.
Now, where do you live?
I live in Mobile
With who?
my mom and 3 of my brothers.
Have you ever lived on your own in your own apartment anywhere?
No.
How old are you?
I'm 28.
How old were you when you learned how to text?
maybe 15, 16.
Did anybody have to show you how to do that?
My mom did a little bit, but as far as that, no.
So you've been texting maybe for about 10 years, give or take? Well, 12 years, I think?
Yes.
Okay. Do you know why you sent these text messages? Okay. Are you sorry that you sent these text messages?
Yes.
Okay. Is there something you want to read to Judge Brown?
I have an apology letter.
Okay. What would you like Judge Brown to know?
Sorry?
What would you like Judge Brown to know?
Your Honor, I am writing this apology letter to explain how much I regret my actions, and I want to apologize to you, Judge, and the state of Florida, and everyone for my actions. I know that we are here today because of me, and it's embarrassing. I hope that you, Judge, and the state of Florida will accept my apology. My actions are... My actions have made me sit and think about what I've done wrong, and I do not think about doing it again. I am scared to even leave my house because of my actions. I can assure the court and the state of Florida I will not commit any more crimes. I understand if you don't believe me, but I am asking the court for me to, that your Honor and the state of Florida have to worry about me even breaking the law again. But I can assure that the court and state of Florida that this will never happen again. I didn't go on the dating site to just talk to anyone but adults. There is no excuse for my actions, and I take full responsibility for what I've done. I feel disappointed at myself for committing these crimes, and it's very humiliating.
I have no further questions.
To the defendant, or I'm sorry, the state?
Just a few. Mr. Merkwa, you told Dr. McDonald that you didn't commit this crime, is that correct?
I did.
But in your letter to the court today, you are saying that you did commit this crime.
I'm taking full responsibility for it.
Okay. No further questions.
Thank you. Can you read your
Just when you talked to Dr. McDonald, were you under an oath to tell the truth?
Yes.
When you talked to her, she put you under an oath? Like you did today?
No, she did not.
Okay. But you're under oath now, right?
Yes, sir.
And did you commit these crimes?
I did.
I have no further questions.
Thank you. Mr. Merkle, you can step down. Thank you, sir. Mr. Hines, any other evidence?
No other evidence, Your Honor.
Evidence from the state?
No evidence, Your Honor, just argument.
Mr. Hines?
Your Honor, I'm going to be asking the court for a downward departure here on the grounds that Mr. Merkwa committed these offenses in an unsophisticated manner, and that these are isolated incidents, and that he has apologized. I put Dr. McDonald on the stand so that Dr. McDonald could give the court a much more intelligent summation of his intellectual issues that he's been dealing with since he's been born, basically. I mean, he repeated kindergarten. He's lived with his parents or his family his whole entire life. He's never lived anywhere else other than with other people. So the court's job, I guess, would be to take Dr. McDonald's testimony and understand the person who's before the court here for sentencing. But legally speaking, it's a pretty straightforward argument for a downward departure. Mr. Merkle has no prior record on his score sheets, or on a score sheet. I'm well aware of what the case law says, that no prior record doesn't necessarily mean that this is an isolated incident. However, in reviewing the case law regarding this particular point, the cases that find or that make a point to say that, there's always evidence before the court that other bad acts have taken place. And there's none before this court. He has no prior record. As as far as I know, he's never been in trouble before he got arrested in this case. If I could, I would be asking the court to place him on community control and to follow that with sex offender probation. I would be the first person to stand in this courtroom and acknowledge how bad these text messages are. There's zero justification for pretty much any of these. So I'm not asking the court to depart because the court should feel bad for Mr. Merkwood. Certainly not. But the court should temper justice with mercy. I mean, without mercy, there is no justice. I mean, that's a necessary component of the entire concept. It doesn't surprise me in the slightest that Mr. Merkwood told Dr. McDonald that he didn't do this. The court, I know, has read these text messages. Mr. Merkwood has a very unusual name, a way to spell his name. As a matter of fact, there's pictures of him. Kind of hard to say that he didn't send them, but I think it's kind of understandable if he's alone in a room with a doctor who is an adult female who you probably would never approach on the street and say, even ask for the time, and she's asking him very personal questions about something that's probably extremely embarrassing. So it doesn't surprise me that he told her that he didn't do that. But he came in here today and he said, yes, that was me. And I'm sure that probably took a lot of soul searching for him to be able to come into a courtroom. I can tell the court he was nervous, and I had to assure him, like, hey, by the time we're actually doing your hearing, these 20 or 30 people aren't going to be here, you know, to try to help him address the anxiety he has. And that kind of was the running theme with Dr. McDonald's testimonies. A lot of this comes back to social anxiety. As a matter of fact, the entire reason that she didn't really recommend sex offender specific treatment is because she thinks that resources would be better spent addressing the social anxiety issues that probably are one of the reasons why he's in the situation that he's in. He has a low IQ, and it's just a kind of an all-around sad situation. Mr. Merkwood never traveled. He never went anywhere. He sent text messages over the span of, I believe, 5 days to two different people. I know in the state's sentencing letter, the state is going to argue that this is not an isolated incident because it involved multiple people. There are 3 cases. This would be State versus Randall, 746 Southern 2nd, 550. That is a 5th district opinion. Granted, it's from 1999, but this is generally one of the, I won't say go-to cases if this is an issue at a sentencing hearing, because in Randall what happened is this individual was selling drugs throughout the month of December, and he made 4 different sales to the same confidential informant, specifically to try to get money so he could buy his kids some Christmas presents. And the 5th DCA said, look, 4 sales to the same confidential informant in the span of a month constitute isolated incidents. Okay, they are close in time. Now they're to the same person. The Randall case is a little bit different because there are two allegations here. But the close in time aspect is, I think, what the courts want the trial courts to focus on is the closeness in time. Another case from the 5th DCA, I believe, 4th DCA. This is State versus Crossley Robinson, and that's 275 Southern 3rd, 662. And in that particular case, downward departure was denied because there were multiple bank robberies during a 6-month period. So, I mean, that's half a year. So it's kind of hard to say these are isolated incidents if it takes half a year. That's not what the court is looking at here. The court is looking at a span of less than a full calendar week in 1 month, in the month of August of 2021. Another case, which is older, and I think this predates the current sentencing structure, is State versus Merritt, 714 Southern 2nd, 1153. This is a 5th DCA opinion. It was issued in 1998. But reading it, I got the impression that this was actually probably something a sentencing that took place in 1997. But there, the trial court found that the 3 sex acts committed by Mr. Merritt had been isolated because they were something the defendant had never engaged in before. He was 25 years old at the time. They took place in a relatively short span of time. That's a direct phrase in this opinion, relatively short span of time, and he had no prior record. And the 5th DCA here says that, and this is a direct quote, "That appears to us a reasonable interpretation of the statute, keeping in mind that criminal statutes should be construed liberally in favor of the person charged with the crime." So there's no prior record. The reason why I asked about the text messaging, I really wish kind of an opinion would come out saying sending text messages is just not a technologically savvy thing to be doing in the year 2023. I'm guessing that it probably doesn't exist because nobody thinks that it needs to be said. But sending text messages using social media applications in this day and age is not the same as doing it in 1993. It's just not. In 1993, half of us would have not even known what the internet was, let alone how to use it. This day and age, almost every single person walks around with a small computer in their pocket. And so we believe that the defense has proven that a downward departure is available to the court because Mr. Mirkwood did apologize. He did show contrition, which is a necessary component of this type of a departure. These are isolated incidents, relative short span period of time. The punishment, I think, should be tailored to fit what the court is facing right here. There is no traveling. There's bad text messages. I'm asking the court to put Mr. Merkel on 3 years of sex offender probation, follow that with 2 years of regular probation. As a condition of probation, I have zero problem, and I actually talked to probation about sex offender counseling, because I was kind of thrown by Dr. McDonald's recommendation to avoid that altogether. I thought, no, that's ambitious, but I certainly think it would be appropriate and necessary here. Mr. Merkel should have to submit to a sex offender evaluation and any follow-up treatment. He is asking the court to adjudicate him guilty. He has never been adjudicated before. He would be a convicted felon. He, by law, would have to be a registered sex offender from this point forward. I have discussed with Mr. Merkwa, if the court grants the downward departure, the fact that he cannot go home right away, that he actually would have to report to probation tomorrow here, and then essentially continue to live in whatever hotel he's in, because he's not allowed to go back to Alabama until Alabama checks his residency. So he would have to stay here for, I believe, up to 5 days before he'd even get permission to go back home. So the residency is really kind of what's, I won't say it's causing problems, but it's limiting what I can ask the court to do. I have no problem if this court wants to make this painful for Mr. Merkwa. I think he's frankly kind of earned it a little bit. I mean, but I can't ask the court for CC because probation is crystal clear that Alabama's not going to enforce the community control. So I can't ask for it, or I would. But I'm not going to ask the court for any sort of suspended sentence, or I don't think if the court agrees to a downward departure here, I don't think that the court or the state should be limited in the punishment that they can seek if there's a subsequent violation, although I don't believe that that's going to be an issue.
Thank you, Mr. Collins. To the state.
Judge, given all the technological issues, did you have a copy of my sentencing letter, score sheet, offense report?
Yes, ma'am.
Okay. Judge, the defendant's before the court on 2 counts of using a computer to facilitate or solicit the sexual conduct of a child and transmission of harmful materials to a minor. Count 4 was dismissed in exchange for the plea, and the PSI recommendation is a guideline sentence followed by sex offender probation with GPS. His score sheet reflects a score of 89.4 points, providing a range of 46.05 months state prison up to the maximum allowable for the offenses of 15 years. We're asking the court today to adjudicate the defendant guilty and sentence him to 6 years in the Department of Corrections, followed by 4 years of sex offender probation and the other conditions outlined in our letter. He's essentially before the court today because he did solicit 2 different undercover officers, posing as a 12-year-old and a 14-year-old for sexual activity, and sent an image and a video of a penis to what he thought was a child. There was first investigator Heather Tice, who was posing as Megan, a 12-year-old, and he chatted with her over Meet Me and text. He asked if she was a virgin, to send him nude photographs of herself multiple times, asked if she's home alone, said he will buy her Plan B, as well as some other solicitation messages. He also solicited Deputy David Rowell, who was posing as a 14-year-old female on Meet Me, Kick, and text messaging for sexual activity. He solicited her as well for multiple nude photographs, sent a bird's eye view video of a man masturbating over a toilet, and a different photograph, an erect penis. He asks if she wants to get pregnant, discusses taking her virginity and masturbation, along with other lewd comments of what he would do to her. And he knew what he was doing was wrong, and he was afraid of being caught. He asks if she's alone or if her father is around. When they discuss meeting up, he says she's just trying to get him into trouble. And he says, I don't want your dad to see them when they're talking about stains on the bed. And he does acknowledge the age of the victims, or alleged victims, in both of the chats. When there's a reference to her being a freshman in school, at one point he says, I get fresh meat too. On another day, when the officer pushes away and suggests that she's too young for him, he says he doesn't care, he loves her, and will wear a condom. He also says, I know you're going to be busy starting high school, I've been through that before. Defense is asking for a downward departure today based on the fact that his offenses were committed in an unsophisticated manner, that it was an isolated incident for which the defendant has shown remorse, and they need to prove all three of those prongs with competent substantial evidence. Court should consider whether there were several distinctive and deliberate steps taken to commit the criminal offense, as well as whether the defendant expressed concern or acknowledged the illegal nature of his actions and had an opportunity to reflect on this or walk away in determining if his actions were unsophisticated. That's State v. Furman 161 Southern 3rd 403 and Bellamy v. State 199 Southern 3rd 480. And I know it's a little bit difficult to see in the chats that were provided to the court, but at least on the call log, it was a little more clear. He had plenty of time to reflect on what he was doing to stop messaging. On the call log, he begins chatting on August 4th at 4:30 p.m. At that point, he chatted all day, went to bed, woke up, and continued to chat until 11:30 p.m. that evening on the 5th. And also on the 5th, he then began soliciting the other undercover officer as well, and that continued at least until the end of the 6th. So there was plenty of time for him to consider what he was doing and walk away, and he didn't. This was also on several different medias. It began on Kik, Meet Me, and then transferred to text message. So we would submit that it was not an unsophisticated incident. Second thing defense must prove is that it was isolated, and obviously, as Mr. Klein's addressed, he did plead to 2 counts of soliciting sexual conduct of a minor and the 1 count of transmission. And we would say that generally, under State v. Monroe, 903 Southern 2nd 381, an offense is not isolated if there are multiple incidences a person is being sentenced for at one time. Even more significantly, in this case, he was caught chatting with 2 different undercover officers, posing as 2 different girls. That's not isolated conduct. He also sent a photo of his penis and a video, which is the transmission charge. They're also arguing that it was isolated because of the lack of criminal record. However, that has been held by the Florida courts to be an invalid, non-statutory mitigator to justify a downward departure. It's because it's already been taken into account when establishing the guidelines under State v. Goggin, 27 Southern 3rd 111. He also acknowledged the illegality of his actions, and he said in the chats not to tell anyone, and he was afraid of being caught. The last prong defense must show is that the defendant has shown remorse. And if this court recalls, the defendant was not truthful to Dr. McDonald and denied all wrongdoing regarding this case to her. He had a story about dropping his phone and finding it later in his neighborhood. And while the court cannot hold it against the defendant for refusing to accept responsibility, case law has found it's impossible for a defendant who refuses to accept responsibility to show remorse for that offense under State v. Ayers, 901 Southern 2nd 942. And the court will note that he did have difficulty today admitting that he committed this crime when he was questioned by me. There's also a difference between being remorseful for your actions and remorse for facing potential consequences. And his lack of candor to Dr. McDonald versus in the court today indicates a lack of remorse for his actions, but more remorse for potential consequences. Therefore, we do believe a downward departure fails on all 3 prongs of this test. Defense also stated in their letter that they're not asking for a downward departure based on the IEP or the social anxiety that was referenced by Dr. McDonald today. So we don't believe defense has met their burden to qualify for downward departure on any basis. However, as the court's well aware, downward departures are a two-step basis. First is whether there's been a legally sufficient basis to depart, and secondly, whether the court believes it should depart, and that's solely in your discretion. We had mentioned Dr. McDonald's evaluations and the various tests she conducted, but her opinion wasn't based on reliable information from the defendant because he wasn't truthful with her regarding the crime or his sexual proclivities. And that was the primary purpose of her evaluation. He was also found average risk to reoffend, which the state would note is far too high in our opinion. As for the school records, the defendant did graduate, received his diploma, and he's almost 29 years old. That alone is not a basis for downward departure. The purpose of criminal courts is not to rehabilitate the defendant, it's to protect the public and hold the defendant accountable for his actions. His words and actions in those chats indicate he had every reason to believe he was talking to two girls that were minors, and that's what his punishment and sentence should be based upon. While it's fortunate there were adults at the end of the line in this particular case, instead of children being victimized, the reason that law enforcement engage in this type of work is to prevent children from being victimized, and that's why the legislature enacted this law. A lot has been said about the defendant and his life and some of his learning disabilities today, but let's not forget about his actions that led him here in front of the court, and that was soliciting two different undercover officers for sexual activity, posing as a 12-year-old and a 14-year-old child. And that is very unusual. And we would ask the court to really consider that during one single operation, he was caught soliciting what he thought were minors twice in the span of about a week. That's significant. And the state would submit that that alone absolutely makes him dangerous. I believe his intentions in chatting with the 12 and 14-year-old girls were very clear, and we explained that previously. So for these reasons, we're asking the court to sentence the defendant to 6 years in the Department of Corrections, followed by 4 years of sex offender probation, designation, place him on a GPS monitor, and all other requirements we had outlined in our letter previously.
Thank you. You mentioned two different applications. You said meet me and something else, and then you said text message.
Meet me, kick, and text messages.
Kick. Okay. Thank you.
Thank you, Judge.
Mr. Kleins, finally?
Your Honor, I just wanted, before I forget, I have the Gohagen case that Ms. Barrickman just cited. It sounds to me like if you read that opinion, I've never come across a judge, but this judge, in the Gohagen opinion, this trial judge, it looks, the way this opinion reads is that he found a downward departure for multiple different reasons. One was because the defendant pleaded guilty. I've never even considered arguing the fact that somebody just pled guilty, that means that they get a departure. Two, he admitted that he failed to re-register as a sex offender in that case. Third, the trial court noted Applee's underlying conviction for lewd and lascivious conduct. Fourth, the trial court noted he was placed on probation for 5 years. Fifth, the trial court found I don't understand why the appellate court would be going through each one of these unless that judge specifically said, all of these reasons is why I'm giving him a departure. And I do agree with Ms. Barrickman about the lack of a prior record. I mean, this judge even gave a departure based on the fact that the defendant was married with a child and had a job. I'll agree that lack of a prior record all by itself is not a basis for a downward departure. However, the legislature has specifically said if it's an isolated incident, and the case law says if they have too much of a prior record, then it can't be an isolated incident. That necessitates a finding that in the context of this particular departure point, the lack of a prior record 100% is inappropriate. As a matter of fact, it's a necessary finding that the court would have to make that this is an isolated incident. So the lack of the prior record all by itself, if that was a basis to depart, I'd be in here on open pleas at the bench quite frequently. But it's not, and I agree that it's not a valid basis to depart. I would point the court's attention to page 3 of 7 of these text messages. In the middle of that, at 5:22 in the afternoon on August 4th, 2021, this officer told Mr. Merkwa that he was cute. And Mr. Merkwa's response, I think, kind of really, I believe, and this is definitely arguable, but I definitely believe that his response really kind of demonstrates the kind of person that was texting here. When this officer says cute, his response is really in a question mark, and that's at 5:22:52. At 5:28, he comes back and says, "Am I really cute to you?" Like, frankly, this is an isolated individual, probably who would faint if a real woman actually walked up and wanted to touch him and kiss him. And I would submit to this court that this is nothing but fantasy play from Mr. Merkwood. He never traveled. They had to go get him from Mobile. As a matter of fact, whatever the court sentences him to, the court's going to have to assess $190.81 for cost of transportation. He never stepped foot in the state of Florida until he was in handcuffs. So 6 months later, or give or take, he was arrested in January. So this danger to the community, I would say, is speculation at best. I mean, he never really left where he lived to send these messages. These are terrible text messages. I'm not going to downplay how bad they are. They're bad. Our position, though, is that the court should fit the punishment to the individual and the situation before the court. The situation before the court is text messages, a picture, a regrettable picture. I'm not asking the court to not punish Mr. Merkwood. I'm actually asking the court to do as much as I possibly can, short of putting him into custody. If the court honestly believes that we're asking for too much and thinks that some incarceration is necessary, we would ask that the court grant a departure sentence Mr. Merkwood to 6 months in the Okaloosa County Jail as a condition of 5 years of probation, or even in addition to, if the court wanted to do it that way. I'm not trying to avoid this man being punished. He should be punished. It should just be appropriate. He has presented sufficient evidence for the court to find a departure, and that's what we were asking for. I did leave off, and I'll defer to what's in my letter. I know there was 100 hours of community service. I'm kind of modifying how I'm trying to approach things with all of my clients. Is I really think that community service should probably be more readily used, make people benefit the community if they've done wrong. I mean, so that's why I was asking for the 100 hours of community service, so that hopefully, and I know there would be a lot of restrictions on him doing it, but last time I checked, there's not like school-age kids on the side of the highway when he's picking up trash. So that's what I would ask for.
Thanks, Mr. Collins. Mr. Merkwood, to me, this is the toughest sentencing there is. Well, maybe not the toughest. Child pornography is probably is right up there. But, it's difficult. I've heard from other experts, not in this case, that talk about, different propensities of people and those things. The doctor wasn't as strong in those categories as I've heard in your favor, that is. So I appreciate Mr. Burns being here. Doesn't surprise me at all, his testimony. Best friend, you both lived lived close to each other and known each other for 8 or 10 years. No violence in your past. He did say that he sees you with a lot of people, but it sounded like most of those were family. But there were other people. Good guy. Doesn't surprise me a bit that Mr. Burns believes that you're a good guy. And I usually try to hang on to things until the end, but since I'm going through the testimony, I do not find that you showed remorse. Your testimony was that you didn't know why you sent the text. You started crying after saying, "I'm embarrassed," and then later said, "I'm very humiliated." That's why you're remorseful. At least that's the evidence that shows to the court. So I can't find that. I was interested with the doctor. Again, she didn't go on and talk about she talked about the deficiencies. not functioning at someone's age, antisocial personality, but she didn't go in to that more and say, Mr. Merkwa is not going to go out and act on any of these things. Average range for reoffending, that didn't help you any.
I would just like to interject real quick, Your Honor. The reason, and she testified that one of the reasons why that jumped up to the average range real quick was because of the static factors that he can't control.
Understand. Yes, sir. But I look at it from protecting society in that regard, not saying that Mr. Merkle could change that. Social anxiety disorder, but again, didn't really expound on that to give the court a comfort level that Mr. Merkle wouldn't act on that. Don't think about the true consequences of doing the crime, basically. Again, doesn't give me a great comfort level. She didn't say, if you do these therapies, the different help, that's going to protect society more. And her language was interesting. The predisposition of Mr. Merkwa puts him into a position basically to do these crimes. So again, doesn't give the court a comfort level on that. The reason why I asked the state how many different applications there were, I understand Mr. Klein's argument about it being an isolated incident because of the time. The court finds that it's not an isolated incident because of the different applications, the different ways that Mr. Merkwa communicated with the two undercover officers, and that it was two undercover officers. Unsophisticated manner, it very well may be. And I'm like, Mr. Klein's, I hadn't seen any case law on that. But even if it was in an unsophisticated manner and it was an isolated incident and Mr. Merkwa showed remorse, which I don't find that, but even if those are fulfilled, the court does not believe it should downwardly depart because of the two different officers, the language that Mr. Merkwa used in those texts. And so Mr. Merkwa was adjudicated guilty. Mr. Merkwa, though, certainly the mental health part of that helps in regard to the actual sentencing. I don't find that I can do or I shouldn't do a downward departure, but you are adjudicated guilty. You're sentenced to 50 months with the Department of Corrections with credit for all time served. And that is followed by, and I'm looking at both the state's letter and also Mr. Klein's letter. To 2 years of sex offender probation, followed by 2 years of regular probation. You are designated as a sexual offender. I'm not going to place Mr. Merkwa on a GPS monitor. I don't believe that's required. I don't think that's needed in this incident. You will need to complete sex offender treatment during the sex offender probation. provide DNA sample, comply with all the statutory registration requirements. You'll have no unsupervised conduct with any minors, no internet-capable devices while you're on probation. The subject devices are forfeited. All monetary assessments mandated by statute or county ordinance are ordered. That's the court cost, $150 public defender's fee. There's a $40 per month cost of supervision, I think the $100 cost of prosecution's in the court cost. Cost of transportation, $190.81 to the Okaloosa County Sheriff's Office. Will be a curfew from 10 p.m. to 6 a.m., adjustable by probation for work or for education. To the state, anything that I've missed?
No, Your Honor. I was just wondering how you wanted to break down the counts as well.
Okay.
Given there's 5 years jurisdiction of each, perhaps count 1 could be the 50 months DOC, credit for time served, and counts 2 and 3 could be consecutive to count 1 but concurrent with each other for the probation period.
Any objection to that?
I think that makes sense.
Okay, thank you. Mr. Merkle, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, Your Honor.
Thank you, Mr. Merkle.
Your Honor, would the court make a recommendation that Mr. Merkle, if at all possible, be housed at Century CI? It's the closest facility I think I can get to Mobile.
Absolutely. Mr. Merkle, I think it'd be best if you're housed closer to your family, so I certainly make that recommendation.
Okay.
Thank you.
Just for clarification, count 1 is the 50 months DOC, count 2 and 3 are the 2 years of sex offender probation, and the 2 years of standard probation concurrent to each other.
Concurrent to each other, but consecutive to
To count 1, yeah.
Yes, ma'am. Correct.
Okay.
Thank you. Rachel, anybody else in back? Okay, then we just have Madam Clerk's, I think.
No, Your Honor, we have like a 20-minute hearing that, I don't know how we got skipped over, but yeah.
Okay, yes, sir. Gotcha, okay. Okay, thanks. Mr. Martinez's case?
With Attorney Dixon.
No, Mr. Klein says to argue it.
Let's hope so.
Jail at the jail.
Good, got it.
And Judge, I don't have any further business if I could be excused.
If Madam Clerk doesn't have anything that she
All I
needs.
have is felony plea day stuff left over.
I'll handle it.
Thanks.
Yeah.
Okay, just plead a, good, thank you. So Mr. Martinez, motion to correct sentencing error, right?
Yes, sir.
Okay.
Court, just give me 1 second, I just have to let my wife know.
Okay.
Yes, Your Honor. So it looks like Mr. Martinez's appellate counsel filed this motion on the grounds.
Let me first ask.
Sure.
To the state, you object to this?
I'm a little bit, I'm trying to understand what we're doing here today, because there are parts of it that I don't agree with, and I think it mischaracterizes and kind of cherry picks certain parts of the transcript to fit the narrative that it wants. But I don't know if we're here today to determine whether or not we need an evidentiary hearing, because the procedure is kind of laid out towards the end of the motion, and then on the docket, it says status call day. But I'm not quite sure exactly, like, I do agree with the position that based on the wording that was in the transcript, I can understand why this was filed.
Right.
However, it doesn't state some things that were in the transcript that I think are important. And then also, I think there's just areas of the law that I think, based on the cases they provided, there's an argument to distinguish the cases here. I just don't know if we're at a sentencing hearing now again, or what the purpose of this particular date is.
Okay. First off, Mr. Clines.
Yes, sir.
When I read through everything, what I gathered from it is that you were saying that the court erroneously believed that the mental disorder had to be connected to the crime somehow, the criminal conduct, in order for me to use that prong as a downward departure.
This isn't my motion, this is filed by his appellate counsel, so the way I read the motion, that's exactly what she's essentially arguing.
Okay.
That basically, while the court was sentencing Mr. Martinez, Your Honor made some comments, and I don't have the transcript, so the transcripts are all, it's on the clerk.
One of the things that I do that they tell us in judge school not to do is talk.
Right.
Is not say more than you have to. My thoughts are exactly the opposite of that. I put exactly the reason why I'm doing different things, where if I'm wrong on appeal, they can tell me I'm wrong. I don't want a wrong decision to be upheld simply because I was quiet. So
I have a proposal.
I believe at that sentencing, I believe that. Do we need probation anymore? No. Thanks, probation. Thank you so much. You've heard me say ad nauseum that U.S. Supreme Court and all courts try to make decisions using the easiest decision they can before they have to move on to more difficult decisions. And that was an easier decision for me.
What I would propose, Your Honor, is I would propose that the court schedule an evidentiary hearing. I will reach out to the appellate attorney and say, hey, I need a copy of the transcript of the actual sentencing hearing so we all know what was said, because...
You can get that on the clerk's side right now. When they send everything to the DCA, they file it with the clerk, everything that they've sent.
Oh, okay.
And so because I pulled the transcripts up to look at this.
They certify the transcript.
Okay, because I looked at Stack at lunch and I was like, how do we not have the transcript?
Probably because they didn't pull it because, the closed case now, but.
I do think that the court, to make an appropriate ruling here, would have to review the transcript to understand. I have a memory, obviously, of the sentencing, but.
I think the state, and I think we have a duty in good faith to argue honestly, the state, I vividly remember the sentencing agreement, and then I went through and read the transcripts. And based on the language that was stated by the court, I understand why this was appealed, because the language does state, as it does in the motion, that you felt like to satisfy prong one, to move to prong two, there had to be a connection between the mental disorder, the mental health condition, and that. So I understand that we have to come back and discuss that. I think the remainder of my argument would best be left for that evidentiary hearing when we do resentence. But I would just urge, I feel like a motion for clarification might have been better, because we never ever talked about, I would say the transcript actually supports the idea that he's not amenable to treatment. I mean, the court even asked Dr. McDonald, how do I find that he's amenable for treatment if in 2022 he was rejecting mental health counseling?
And let me interrupt you. I doubt, and you correct me if I'm wrong, I doubt I said on the record that that if he does fulfill that prong, then I will sentence him to something or another.
No, you didn't.
Right? Because to be honest with you, once I got to that point, I didn't have to take that next step. And I've got all my notes from that hearing. I agree. I think that, to be honest with you, when I was doing my homework, I thought, gosh, am I going to have to sentence this guy today? Am I going to have to re-sentence him based on this? And again, I've got all my notes, but I think it'd be nice to have the transcript and any other evidence that y'all want to present.
So is the hearing that we will have, are we having to re-argue to sentence him, or are we arguing about what's in here?
What was the end of that?
Or are we arguing about the contents of this? Because we've had a sentencing hearing, so are we using the transcript from that sentencing hearing to re-sentence? What's the mechanisms for this?
I agree.
Because what it seems like to me is they said, because there's a potential that you analyze this prong wrong, we have to come back and do a whole re-sentencing hearing?
Okay, hold on one second. I expressly